the Solicitor General and requested to be present, is that royalty matter, my lords, where one matter was not detached.
Mr. Solicitor, that oil company matter remained to be detagged, so
It needs to be detailed.
so we'll just, I just told them talk to the learned solicitors.
Yes, yes, it needs to be. I'll provide covered by
वो पिछले वाले group में हाँ to be detected oil company.
I'm grateful.
See, I might say something.
Your Lordship, please. This volume 2F is my another brief note submissions. I wouldn't take more than 10-15 minutes. And before I do that, I thought there's another volume 4D, which I did not refer to the other day.
Oh, we don't have that.
It's just volume 4D is a text except of a book on meaning of meaning. It's about linguistics. I have placed chapter 6 for a interesting reading so that we understand sometimes about definition, how we have some issues. I don't propose to read it at great length. Couple of pages, I may just draw your Lordship's attention to that. Before I come to that, let me take your Lordship to volume 2F. We did a little research on the colonial period understanding of intoxicating liquor. And that gives us some insights on how it was understood then. So let me quickly read a few paragraphs of my written note. In the first part, I say that the use and recognition of use of alcohol liquids for other than potable purposes has been a subject matter of discussion during the colonial period. The literature available on this subject gives us insight as to the distinction between classes of alcohol with reference to their uses. It's submitted that entry 8 is based on the said distinction. The literature plays along with this note show that there is nothing in support of the proposition that intoxicating liquor was understood to include all classes of alcohol liquids. Matters of trade and commerce, supply and distribution, etc., referred to in entry 33, or in relation to the products of an industry under the control of the Union. The nature and extent of trade and commerce, etc., will differ from product to product. Clause A of entry 33 of list 3 came in by third constitutional amendment. Enacting such a field of legislation in the concurrent list can be understood from the need for flexible distribution of legislative scope between Union and states. Entry 33 is therefore a classic example of Article 254 proposition. Once it is understood that neither entry list 2, whichever way it is construed, and keeping in mind entries 26 and 27 of list 2, which are subject to provisions of entry 33, laws made by Parliament under the authority of the two branches, namely entry 50 list 2 and entry 33, will occupy the declared field. The use of the phrase "that is to say" occurring in entry 8 only refers to the range of activities concerning one class of alcohol, namely intoxicating liquor, and is not referable to other classes of liquor, trade, commerce, supply, distribution. These are all activities. The approach adopted in Calcutta Gas based on resolving conflicts between entries in the same list does not appeal to logic. The mere fact that entry 25, gas and gas work, is treated as a distinct entry does not mean that any part of dealing with gas and gas work cannot even conceptually fall under entries 24, 26, and 27 of list 2. The emergence and use of gas processes and industries relating such use can be the only reason for a special attention to be paid to gas and gas work. The logic applied in Calcutta Gas cannot be extended to entry 8 list 2. Now go to the literature in the subject. Let's kindly turn to paragraph
Part 2.
3. It submitted India the use of alcohol for industrial purposes and regulation for both subsequent to use and regulation of alcohol for the purpose of intoxication. To understand the regulation of liquor in India, it needs to be understood that colonial laws of the 19th century were guided by twin objects of generating revenue on the one hand and checking intemperance of people towards safeguarding their morality. The reference is available at footnote number 2. The said purpose of the Akbari Acts, for instance, the Bombay Akbari Act, can be evinced from the contents of the reports on administration of the Abkari Department of the Bombay Presidency, Sindh and Eden. For instance, para 6 of the report of 1880-81 notes progressive increase in Abkari revenue, which is accompanied by decrease in drunkenness. Notably, the details of revenue collections notes 4 branches of Abkari revenue, that's foreign liquor, country liquor, intoxicating liquor, and miscellaneous. That submitted that even though all categories of liquor were considered consumable, intoxicant liquor was considered a separate class of liquor that is ordinarily and regularly consumed, which is administered and monitored separately. In the report of the Administration Abkari Department of the Bombay Presidency, Sindh and Eden, published in 1894, the source of the revenue are listed as 1. The principal source of Abkari revenue on this presidency are A. Manufacture and sale of country liquor, which term is for the present purpose to be understood as exclusive of malt liquors brewed in India, and the special descriptions of liquors referred to under clause B below. The manufacture and sale of malt liquors and of certain special descriptions of country liquors, excise that rates leviable under the Indian Tariff Act on liquors imported from foreign liquors. C. The sale of foreign liquors. D. The manufacture and sale of intoxicating drugs other than opium or preparation of opiums. The country liquor tax and consumed are 2 kinds, distilled spirit and toddy or the sap of palm tree. Then next paragraph. The liquor in question during the first century of colonial rule was only the liquor that was ordinarily being consumed. It's also worth stating that the alcohol proof prescribed was never as high as 90% proof as is being discussed today. Even as late as 1919, the report on the administration of the Excise Department, Abkari and Opium in the Bombay Presidency, Sindh and Eden notes at para 4. There was no change in the prescribed sales strength of country spirits sold, namely 25%, 30%, so and so. The policy discouraging the consumption of stronger spirit was further pursued by the restriction, where feasible, of additional shops. Then paragraph 7. It was at the turn of the century that alcohol achieved a different dimension. Then turn to paragraph 8. With the increased use of alcohol emerged from the issue of liberal taxation for industrial alcohol and the conundrum that's being faced with the Honorable Court as to what constitutes industrial alcohol. This issue was considered by the Industrial Alcohol Committee in the report of 1920, where it observed, "We have some difficulty in finding a satisfactory definition of the term industrial alcohol and in avoiding the purely subjective definition of alcohol intended for industrial purposes." At first sight, this would appear to be the only possible description, as there is no intrinsic difference between alcohol intended for potable and non-potable purposes. Possibly the best definition of alcohol, which is exempted from the excise duty leviable on potable spirit on the ground that is intended for non-potable purpose. This will cover both pure alcohol and alcohol, which has been denatured, that is rendered unfit, more or less completely for human consumption. It will also cover the use of alcohol in experiment and research are distinct from purely commercial uses, where the object is to place the finished product on the market by will, exclude the use of alcohol in hospital and in the preparation of medicines and tinctures. Industrial alcohol, as defined above, is alone dealt with this committee. The British Interdepartmental Committee on so-and-so paragraph for the report that all alcohol for power attraction purposes should be described as power alcohol. This is satisfactory so far as it goes. And we have made suggestions for the definition and regulation of such power alcohol. At the same time, they suggest the term industrial alcohol is unsatisfactory on the ground that some section of the community believe it to be alcohol for the working man. Such misapprehension is not likely to arise in India. Power alcohol is a subdivision of industrial alcohol, and we see no reason to abandon the logical classification. The report also made certain recommendations for preparation, transport, and taxation of power alcohol, that is industrial alcohol used for fuel or motor vehicles. Then, paragraph 5, the report, the final report of it. All local governments should be required to revise the rules regarding other forms of industrial alcohol so as to clearly discriminate from alcohol intended for portable purposes and to provide for grant of special licenses for experiments in the production and use of alcohol, for the use of rectified or specially denatured spirit in industries, and they should also bring their rules into conformity in various minor matters, especially as regards denaturation test, the permissible quantities of private possession and the retail strength of ordinary denatured spirit. So that gives us a very important insight as to the pre-colonial understanding and how it has not faded away with intoxicating liquor being treated as an entry in item number entry 8. There are only few observations I want to make. Then constitutional debates, my learned solicitor will extensively deal with that in volume 7. It's also understand the same way. And for instance, Sirvai talks about it in his volume 2. Intoxicating liquor as meaning liquor which is consumable. And Justice Sinha notes about it in the judgment. So there are aspects which the solicitor learned friends will deal with. I thought this is an important insight about what happened, which went into the understanding of intoxicating liquor. So if you just also look at volume 4D, that few pages there, the question of difficulty with definitions. It's a very important insight as to how we have all the difficulties in definitions. And at the opening page, there's a quote from Oscar Wilde's 4-act play, Lady Winderman's Fan. It's very interesting. So this is how it reads. Do as a concession to my poor wits, Lord Darlington, just explain to me what you really mean. I think I had better not, Duchess. Nowadays to be intelligible is to be found out.
Okay, thank you, Mr. Attorney General. Thank you.
Very well.
Thank you, Mr.
Very well.
Yes, Mr. Solicitor.
Please.
May I take the Lordship's leave? May I take the Lordship's leave?
Wait, please. But my submissions are in volume 2D.
Volume 2.
2D, my lord. There are, earlier I have filed 2C, which is modified. So kindly ignore 2C, my lord. If my lord, possible, technically I will delete 2C so that there is no confusion. There is nothing, my lord.
But yeah, it may be just updated and...
Yes, that's all. There is nothing
There's no
which
duplication.
has wrongly gone into 2C and I am trying to. This is updated, brought in a little better flow.
So we just say 2C to be ignored.
Yes, 2D. But I would wish to read, my lord, the questions first, and the reason is this. My lord, except one question which directly concerns alcohol as a product, rest of the questions are on interpretation and interplay between the Constitution of India and the Industrial Development and Regulation Act. Lord, though your lordship, my lord, the Chief Justice was right that many of the products are de-licensed now, but many of the products continue to be under the licensing era. Even alcohol partly is under the licensing era. And therefore, whatever your lordship ultimately adjudicates is bound to affect the operation of IDRA vis-a-vis the scheme of the Constitution. And there are certain paramateria, entries like 52. Please come to, my lord, page, PDF page 2. These are the questions. Does section 2 of the IDRA have any impact on the field covered by section 18G of the said Act or entry 33 of list 3 of the 7th schedule? Well, this is a generic question. Does section 18G of the Act falls under entry 52 of list 1 of the 7th schedule or is covered by entry 33 of list 3 thereof? In absence of any notified order by the central government under section 18G of the above Act, is the power of the state legislature in respect of matters enumerated in entry 33 of list 3 ousted? Does the mere enactment of section 18G of the above Act gives rise to a presumption that it was the intention of central government to cover the entire field in respect of entry 33 of list 3 so as to oust the state's competence to legislate in respect of matters relating thereto? Does the mere presence of section 18G of the above Act oust the state's power to legislate in regard to matters falling under entry 33A of list 3? Up to here, these are generic questions, which would hold the field, my lord, forever till it is doubted or referred something. But IDRA, any schedule industry being brought under it, would be covered by what your lordships would now decide. And last question, does the interpretation given in synthetics chemicals, that is synthetic 2, in respect of section 18G of the IDRA, correctly state the law regarding the state's power to regulate industrial alcohol as a product of the schedule industry under entry 33 of list 3 of the 7th schedule of the Constitution in view of clause A thereof? Now, please come to, my lord, page 3, which are the existing statutes under entry 52 list 1, which would directly be affected by the first questions except the last one. The Coffee Act, Rubber Act, the Rice Milling Industries Act, the Cardamom Act, Coconut Development Act, etc., etc. But this is an illustrative list. There may be other laws also. This is only to point out that kindly do not consider this question only from the prism of alcohol industry. This would be, my lord, a wider question affecting every schedule industry which is included in the schedule appended to this act. Now, my lord, some of the things, my lord, which are never pointed out to your lordships right from Tikaramji, and that is why, my lord, I would ultimately say Tikaramji is wrong. My lord, I am placing for your lordship's consideration. The first thing, my lord, which is never pointed out either in Tikaramji or in any subsequent judgments which follows Tikaramji. None of the judgments, my lord, your lordships, had the assistance of these facts, these position in the Constitution. And that is, so just giving an example. Well, Tikaramji says that industry has a restricted meaning, meaning it includes manufacturing activities. It doesn't say why. There is no logic, there is no rationale given, there is no discussion. But in the Constituent Assembly debate, Dr. Ambedkar elaborates the term and width of the word industry. But there are 4 compartments in which, my lord, your lordships will have to be assisted to reach a correct conclusion. My lord, this is not a center state issue. So, my lord, this is not, my lord, an adversarial position. I am taking a position to assist your lordships. Because UP is here, my lord, Maharashtra is here, there is nothing political or, my lord, any federal dispute, etc. So, there are 4 stages your lordships will examine while interpreting each entry. First is, my lord, called devolution rules. My lord, in 1919, Government of India Act was passed,
Yes.
which bifurcated the subjects between the federal government, which is the central government in the present parlance, and the provinces, that is the state government in the present parlance. That is called devolution rules.
Yes.
Thereafter comes Government of India Act 1935, where again Lord, this bifurcation of legislative competence between federal government and the provinces took place. Third is the draft constitution, my lord, prepared by the drafting committee chaired by Dr. Ambedkar. How they used certain expressions qua each provision and qua each entry. Now, that draft entry or a draft constitutional provision was debated, and how it takes form of what the constitution is at present. Lord, I have attempted to, my lord, show on every my lord, provision which is coming for your lordship's consideration, all the four. And if your lordship's, my lord, would subject to your lordship's, my lord, approval, I can say, my lord, if your lordship finds that if this would have been pointed out right from Tikaramji, or at least at some stage, Tikaramji would have been differently decided. My lord, please come to, my lord, page 5, page 6, my lord. But I am skipping what is not, what I have already orally pointed out, my lord. But I come to entry 52 first. Your lordship said, my lord, PDF page 6. My lord justice.
Yeah.
My lord, para 6 I'll read with your lordship's permission. Some of the industries have always been considered to be necessary to remain under the central control if it is found to be in national interest. Now, throughout, there is a chain of three considerations: industry, the functioning of which has a national interest; B, the industry, the functioning of which needs decision making at the pan-India level; and 3, the industry, the functioning of which needs the regulation in such a fashion that the product is equitably distributed. My lord, your lordships are aware, my lord, as we pointed out in mines matters also. My lord, some of the states are endowed with some of the most important resources. Rest of the states do not have the benefit. And if the constitution feels that it is to be left to the parliament, that a particular industry should be centrally governed, not provincially governed, because provincial governments would take provincial provincial perception, and the central government would have a holistic perception. Those industries have always been conventionally, traditionally, and constitutionally be under the center. Lord, now corresponding entry in the devolution rules. The first devolution rules made under Government of India Act 1999. That is
Solicitor, all our young juniors, stand day after day. I've been noticing, with their laptops and in their hand. In the afternoon, the courtmaster will just see if we can accommodate them behind you immediately so they can sit for the day.
Yes, Manoj, that's what Manoj, I was saying.
I just told the courtmaster to find out.
Manoj, who are not appearing, for example,
Also, we'll see if we can even put some stools or something like that.
No, Manoj, some of the councils, Manoj, are not appearing in the matter. They can, Manoj, perhaps accommodate those who are appearing.
But we'll try and put some additional chairs also for the juniors so that they have to be close to whoever is arguing.
Yes. So kind of your lordship. But I am immensely grateful. But entry 20. This is the route. 1990 Government of India. Development of industries in cases where such development by a central authority is declared by order of the Governor General in Council expedient in public interest. Well, development is underlined by me. It is my emphasis. Now come to what happened in 1935. It remains the same. Development of industries where the development under federal control, the word used is now federal control, is declared by federal law to be expedient in the public interest. Federal law is earlier version of parliamentary law. Now, how the drafting committee drafts this entry. Development of industries where development under the control of India is declared by Parliament, by law, to be expedient in public interest. It retains substantial heart and soul, but makes minor changes. Now, please see, how it stands today. And there is a reason. The reason is explained in the Constituent Assembly debates. The word development is replaced by the word control.
And there is, interestingly, if you see our constitution, though, of course, we now know it's a federal constitution. That's how we have interpreted. Constitution doesn't use the word federal anywhere at all.
Yes.
Unlike what happened across the border, if you look at the Pakistani, they have used the word federal government, federal. We don't use the word. We have used central, union, but we have eschewed the word federal in the constitution.
I think, this is
my semantics more than anything else, but at least in the birth of the constitution, they didn't use the word federal.
It's my perception, subject to your lordship's approval. The federalism has several facets. Your lordships, I'm not going on general principles of it is quasi-federal and leaning towards unitary, etc. I'm not on that. When it comes to the subjects which need distribution of national resources, we have, for example, 25 federating units, hypothetical example, 25 states. The classical definition of federalism means each unit is independent in its own way. It's not sovereign in the way American states are sovereign, but they are independent in their own way. Any interference by the center may perhaps breach the element of federalism which is involved in the constitution without naming the term federalism. But now, kindly see this nuance which is my perception. When the center, having an authority under the constitution, does something to ensure that 3 or 4 states having incidentally major resources of a particular character do not deprive rest of the provinces, namely federating units, of their right of equal treatment, and the center interferes and makes equitable distribution, that is also an element of federalism. So there, to maintain federalism, the power is conferred upon the center. That now you step in. The only condition is the center must have a backing of a constitutional provision to do so. And entry 52 is one such provision. And it is, in my respectful submission, in furtherance of the principle of federalism. Please see page 7. Industries declared by Parliament by law to be necessary for the purpose of defense or for prosecution of war. I have put it here because entry 24 list 2 mentions entry 7, therefore for immediate reference.
Yes.
And 52, the way ultimately found its place in the constitution as it stands today, industries, the control of which by the union is declared by Parliament by law to be expedient in the public interest. The earlier 1919, 35 and the draft used the expression development. Now it is replaced by the word control. And there is a debate. Why are you doing this? Some of the members felt that why are you curtailing the power of the Parliament? And the answer given by Dr. Ambedkar would show that Tikaramji is wrongly decided because this is not pointed out. Tikaramji, in so far as it says that industry is restricted to only manufacturing, my lord, is contrary to what the constitutional framers envisaged. My lord, page 7. My lord, let me read this debate, my lord, in extenso, because this would have serious bearing on what ultimately your lordship decides. Honorable Dr. B.R. Ambedkar, sir, I move that for entry 64, my lord, 64 is present 52.
Yes.
For entry 64 of list 1, the following entry be substituted. My lord, whenever there is a change in the draft constitution and what is moved, my lord, the word used is substituted. Industries, the control of which by the union is declared by parliament by law to be expedient in the public interest. My lord, then my lord Kaka Bhagwant Roy, my lord, says this, that he moves an amendment in this, that in amendment number 35 of list 1, in the proposed entry 64, that is present 52, the word industries, the word development of industries be substituted. It appears from the amendment which the Honorable Doctor, no, this is the parliamentary debate. It's not my noting, my note or
This is
something.
the Constituent Assembly
The
debate.
Constituent Assembly debate. I only highlighted. Highlighting is, my lord, supplied. It
I like the
appears
way
from
you call the Dr. Ambedkar, the Honorable Doctor.
Yeah, yes.
Deference to Dr. Ambedkar.
to the person, my lord, and the persona. It appears from the amendment which the Honorable Doctor has introduced in the original entry that he wants to hand over all powers regarding industries to the center. It is very good. Center ought to be strong, and during transition, the center should be vested with such powers as are essential for the industrial development of the country. But in normal times, the center should not be vested with such authority. India is a very big country. She has many provinces. These provinces have their own difficulties and can understand their problem much better than the center. The problem of industries is very complicated. Therefore, so far this question is concerned, every province should be given facilities to solve its own problems. If you make the provinces responsible for industrial development and do not give them powers to deal with the situation, then the problem of provinces cannot be solved and it will retard the industrial progress of the country. Although I am somewhat deviating from the point, yet I must say that the present industrial policy of the center will prove a stumbling block in the path of the country's progress. Kindly pause here for a minute. Historically, the first industrial policy came in 1948 when the debates were ongoing. And Lord Kaka Bhagwant Roy was a prominent leader who was opposing that industrial policy per se. Therefore, he says that I am deviating, but I don't agree with the industrial policy. Nothing turns on debates, though. Mr. President, you are only speaking on your amendment, but you are opposing it. Kaka Bhagwan Roy, I bow down to your ruling, but I would like to say that so far industries are concerned, the provinces should be entrusted with necessary powers, for they can understand the problem of their industries better. With these words, I would request the Honorable Doctor to accept the amendment. Then, my Lord, Sri H.V. Kamath comes. I move the amendment as under, that in the amendment 35 of list 1, 6th week, in the proposed entry 64, my Lord, present 52, for the words the control, the words the development and control be substituted.
Yes.
Then he further, sir. Then, my Lord, Mr. Kamath further makes his point before the Constituent Assembly. This amendment includes or embraces the amendment just now moved by Honorable Friend Kaka Bhagwant Roy. The original entry as it stood in draft constitution referred to the development of industries. I wonder why the drafting committee has suddenly developed an antipathy to the world development in this entry. My lord, Mr. Kamath seems to have the very good sense of sarcasm, my lord, which will come, my lord, further. My amendment is on the lines of a legislative measure which was introduced in the Assembly during the last budget session and which has been referred to a select committee. The bill provided for governmental action in industries, the development and control of which was to be regulated by the centre, and the title of the bill was Industries Development and Control Bill. That is to say, the subject matter of this entry has been already taken cognizance by the central government in a bill, the title of which includes not merely control, but the development of industries which are deemed necessary or expedient in public interest. Now he is, my lord, sarcastic. I realize it is quite possible the drafting committee, owing to the excessive strain under which it had labored during last 2 years and especially during the last few weeks or months, is liable to commit slips here and there. But I hope that the drafting committee has not developed a closed or calcified mind which is not receptive to any change whatsoever. But the sarcasm also, my lord, was with a reasonable degree of respect and restraint.
Yes.
I think that the meaning of this entry will be more adequately and more fully covered by amending this word control on the lines I have suggested and seeking to incorporate in this entry not merely control but also the development of industries, which means industries, the development and control of which by the union is declared by parliament by law to be expedient in public interest. I move amendment so and so. Now, my lord, Dr. Ambedkar answers this, and this is missed. This is the heart and soul of entry 52, which is not assisted with either in Tikaramji or any subsequent judgments which follow Tikaramji, so far as the width of the term industry is concerned.
Yes.
Honorable Dr. B.R. Ambedkar, sir, the entry as it stands is perfectly all right and carries out the intention that the drafting committee has in mind. My submission is that once the center obtained jurisdiction over any particular industry as provided for in this entry, that industry becomes subject to jurisdiction of parliament in all its aspects. Kindly mark this, my lord. In all its aspects, not merely development, but it may be in other aspects. Consequently, we have thought that the best thing is to put the industries first so as to give undoubted jurisdiction to parliament to deal with it in a manner it likes, not necessarily development. Once the industry comes in the first schedule of IDR Act, all its aspects are within the control of the central government. And Tikaramji says, no, only manufacturing part. How, why, what rationale, no reasoning, no assistance, and this is completely absent.
At least the view that was given by Dr. Ambedkar, as it appears, was that when the control over industry is given to union, it will cover all aspects and will not be restricted to what is given in Tikaram, that is manufacture. Now, what are the all other aspects? Can we just articulate straight away?
In my respectful submission, this is not from the debates. But when Dr. Ambedkar says that once it comes within the control, all aspects would come in the control, my lord, would be right from sourcing the raw material till the distribution of the product. And I'll tell you, Lordship, why. Why, my lord, this is my respectful submission. Lord, which are these industries which are intended by the framers of the Constitution to be put under 52? The entries, my lord, as the judgments and the subsequent development goes, where the central government or the center needs equitable distribution and at fair prices. My lord, I'll take your lordships to the
That is the objective.
introduction and the SOR of IDR also, my lord, throws a direct light. And therefore, for example, my lord, taking this example just to answer your lordship's query. But in a given set, I'm sorry, my lord, the chief.
Yes.
But even given set of facts, my lord, maybe 10 lines, 10 years down the line, or maybe 15 years before, there is a scarcity of sugar, which happened, my lord, during Second World War. The sugar was imported into Britain, and because of the Second World War, all imports were stopped when Churchill took over. Suppose some situation arises. The raw material for production of sugar is sugarcane. If all industries which are dealing with sugar or using sugarcane as a raw material start using sugarcane only for the purpose of, say, making alcohol and not sugar, the central government can step in. Suppose considering the situation at a national level, the sugarcane growers say that we will not sell the sugar to sugar factories. We will sell only to alcohol factories because we are getting more price. And the interest of the nation is that right now we need production of sugar more because we are deficit in sugar. That's the intention. If that is the intention, then how, my lord, I'm posing a question to myself, we exclude the raw material from the control. Central can do nothing, my lord, in the example which I have given. That country needs sugar, there is a sugar scarcity, sugar production needs to be enhanced, which even Tikaramji says manufacturing is within my control. But the raw material growers, the sugarcane growers say, no, we will sell it to only that factory which makes either potable or non-potable alcohol, because I am getting more price. The central government can come out with a regulation that no, this is the way in which you will distribute your raw material. You distribute your product, which is a raw material for the industry.
You know, some specific parts of an industry, even after a declaration is made under entry 52 of list 1, is taken out of the scope of entry 52 of list 1 by entry 33 of list 3. So distribution, because entry 33 of list 3 is not a matter of interpretation, it's a constitutional prescription that even after an industry is declared under entry 52 of list 1 as an industry, the control over which is deemed necessary by Parliament in public interest, the central government in public interest. Despite that, entry 33 says, trade and commerce and production, supply and distribution of the products of any industry, whether control of such industry by the union is declared by Parliament by law to be expedient in the public interest. So clause A of entry 33 clearly has a reference to entry 52 of list 1, though it does not specifically refer to entry 52.
Doubtless.
Right? Therefore, at least that part, even if it is declared under entry 52 of list 1, that part which falls under entry 33 of list 3
will be
is
extracted.
taken up, is extracted away from entry 52 of list 1.
No,
And then given to the states as well as the center.
It is added to the term industry as understood in Tikaram. That not just manufacture, you can include product, its distribution, etc. But I just gave an
in fact, entry on a slightly different plane, entry 33 seems to indicate that entry 52 would not otherwise be confined only to manufacture. Because if entry 52 was confined only to manufacture, there was no need to create entry 33. Entry 33 was to carve out something out of entry 52, which would have otherwise been within the fold of entry 52. That's really
expanding the 52.
But what it does is, in recognition that entry 52 will cover trade, commerce, production, supply, and distribution, it takes it out of entry 52 and puts it in entry 53.
This is, my lord, since I was answering my lord's question, my lord, my proposition, which I will develop a little later, if I am right and I have understood, my lord, Dr. Ambedkar's understanding correctly, then even in absence of entry 33, my lord, can the Parliament not only under entry 52
of course
control everything
That was Dr. Ambedkar's understanding, but they were not dealing in that part with entry 33 of list.
There is an interesting debate on entry 33 as well. But, my lord, I am putting it in two alternative ways, my lord, for your lordship's consideration. A, please consider entry 52 the way, my lord, in my submission, Dr. Ambedkar understood that everything concerning the industry. Then, my lord, I don't have to fall back on entry 33, list 3 also. Parliament can exclusively under 52 enact a law which takes into consideration right from raw material till end product and its distribution. But alternatively, 33, my lord, as your lord, my lord, the Chief Justice has rightly said, my lord, would come in the aid. And why entry 33 came, my lord, I'll assist your lordship.
In fact, part of the IDRA may be traceable to entry 52. Part of the IDRA may be traceable to entry 33 also.
It's a ragbag legislation, that's our argument.
Parliament is also competent under entry 33 to control production, trade and commerce, production, supply and distribution.
Why are we, all of us on this side, my lord, are enamored by the raw material part? Because Tikaramji happened to have that fact situation. Otherwise, there is no doubt that if you control an industry, you control every part of industry, start from finish. But Tikaramji, as a matter of fact, Tikaramji, which is consistently used for a proposition, which it did not decide. I'll come to that, my lord. Tikaramji, my lord, kindly, just I'm flagging it for your lordship so that it can be kept in mind as per my submission. Tikaramji, the ratio in Tikaramji is merely this. There is an IRDA and there was a state act. Sugar was when Tikaramji was decided a scheduled industry and therefore IRDA applied. The state law concerned sugar cane, and the question was, is there any repugnancy between the central law which governs sugar and the state law which governs sugar cane? The court examined both the acts and says there is no repugnancy. It should have stopped at that. Anything other than that, I'll show, my lord, because unfortunately 1 or 2 paras were cited in Tikaramji, my lord, before your lordships and subsequently also. Everybody has cited 1 or 2 paras without showing, my lord, the background, factual narration and what exactly is the ratio in Tikaramji. Tikaramji merely says that there is no repugnancy between IDRA and the sugarcane control order of the state government. That's the only ratio. Now, my lord, I'll proceed further, my lord. Page 9, after Dr. Ambedkar's, my lord, reply. My lord, this is accepted, my lord. I need not read it further. Please come, my lord. Page 10.
This argument is accepted. 33.
Kindly come to, my lord, para 10 now. Page 10, para 8. Lord, I have said Tikaramji doesn't take note of this. Lord, I have a separate argument, separate section how Tikaramji is not a good law, A, and how Tikaramji's few of the findings are only obiter because it was never called upon to decide that. But that's a separate issue. I am not, my lord, touching that right now.
Used in NT33. The word production is used because there are lots of industries which are not covered in any of the lists. For instance, textile industry, leather industry, so on and so forth. So, supposing it is not taken over by the, not taken over by.
I agree. Therefore, concurrently,
IDR.
state also
IDR.
can, subject to 33A. If there is a 52 law, state cannot. Otherwise, but state can. That's,
So
therefore,
what happens is,
concurrent.
not if supposing not the industries are not the ones which are specified in list, perhaps not entry 52 list 1, then the production may also go there. No, there are certain industries specified in list 3 itself. There are certain industries like electricity and other things specified in list 3. Now, where would the production go then? Obviously, it can't go to list 2, it can't go to list 1, it has to go to list 3.
Correct, Manoj.
So that's the reason, Lord, why production is used there. That's all I wanted to clarify, Lord.
Anyway,
Rest
you
we'll
can
explain, we'll
please
explain
don't,
Dr. Ambedkar's observation.
Yeah, I would request Mr. Dwivedi not to.
Therefore, yeah, we quite understand that once an industry is declared as a controlled industry, we use that expression under NT 52, ordinarily everything would be covered by that aspect.
There is one more example I can give. The Lordships recap.
Because whether Parliament regulates it or legislates upon it under entry 52 or entry 33 is really, it was one significance. That if Parliament is regulating on those 5 subjects, trade, commerce, production, supply, distribution, then it is regulating only under entry 33. The consequence is, 1, the parliamentary law is supreme. 2, the states can also enact a law.
Subject to 254.
Yes, subject to 254. So states can enact the law unless Parliament intended to exclude all power of the states to enact the law under entry 33. Parliament can always do that.
But if there is a law under 52, entry 52, then 33A would denude the state legislature from
extent.
its power on trade, etc.
That extent.
Yes, to that extent.
No, not,
No, not to that extent.
No.
It's up to that extent.
That extent.
For trade, etc. Correct.
And there's one addition to your written submission which I'll make. Just one phrase. Just 1 second. I was just thinking I'll tell you that at this point. Then there's no problem. Then it's absolutely we are all on one. In your para 8 where you say,
Yes. The restrictive meaning.
Just read that, Solicitor, again.
Well, may I read?
Yes.
The restrictive meaning to entry 52 list 1 given in Tikaramji and followed subsequently in subsequent judgments relying upon Tikaramji in absence of being assisted with the crucial constituent assembly debates is thus not a good law. The Parliament under list 1 entry 52 is fully entitled to control everything as per its wisdom, the requirement of particular industry, the requirement of particular industry, and to achieve the stated object of IDRA when Parliament is satisfied that. So this is SOR and the industrial policy.
There I would only make one little addition.
Please.
The Parliament under list 1 entry 52 and list 3 entry 33. The only thing is that the latter is also subject to state concurrent powers. Subject to Article 254.
Well, that doesn't affect my argument, but hypothetically as an academic question.
Well, once we say that Section 18G of the IDRA is traceable because 18G seeks to impose measures on controlling trade and commerce.
But not production.
Not production, trade and commerce.
Production is already.
Trade and commerce.
I would, my lord, request for, we never did this.
If a Section 18G covers trade and commerce, supply, distribution, all right, then to that extent, Section 18G requires a notified order. And in the absence...
Lord, yes, that's a separate argument. There is a separate argument. My lord. I have an argument on absence of notified order under 18G, plus 18G is not the only provision which occupies the field under entry 52, read with 33.
And if 18G does not cover production...
There are other provisions. The entire act is not read before you.
Read the act, Mr. Solicitor.
Yes,
all right.
18G is not the only
stage, actually, we'll move forward. At this stage, we wanted to only flag that true, entry 52 on a declaration is comprehensive. The control is comprehensive. But however comprehensive the control on a declaration under entry 52, it will still be subject to entry 33, entry 33. Because entry 33 extracts out of 52 certain aspects, 5 facets, and places it in the concurrent.
Just academically, my lord. To
because
assist
clause A of entry 33 is a direct reference to entry 52.
Let us, my lord, leave it at that. My lord, I have another.
Just look at it. Entry 33 says 33A, so that we have absolute conceptual clarity on this.
Yes.
Now, see, interestingly,
Yes.
entry 52 is not made subject to entry 33.
Yes.
Right? Because entry 52 has not been made subject to entry 53. But if you now see entry 33, are there any entries in list 1 which are made subject to list 3, by the way?
No, my lord. Not to our knowledge, but
Not, I don't think there's anything like that. Entry 32, right? That property of the union subject to legislation. That is correct. But there's no entry specifically in list 1 which makes it subject to list 3, right?
My learned friend wants me to see property, the union and revenue therefrom, but as regards the property situated in a state, subject to legislation by state, save insofar as Parliament by law otherwise provides. So again, parliamentary supremacy.
Now, See, if you look at now entry 50, let's see 52 first.
Yes, ma'am. 52. Industries, the control of which by the union is declared by parliament by law to be expedient in public interest. Lord, kindly examine the scenario.
Now, Mr. Solicitor, just conceptually, now let us look at 33 for a moment.
You must say not in public interest.
The word,
It's mentioned in the first schedule. And first schedule is only with regard to manufacture or production. But when it comes to 18G, production is not there. There it is control of supply, distribution and price. There is a distinction.
Lord, please bear in mind, 18G is the only section relied upon by them.
you are looking at other sections.
I am going to look at other sections, show other sections also.
Fair enough. But one thing which I wanted to point out to you is this, that entry 33A, the expression, the control of such industry by the union is declared by parliament by law to be expedient in the public interest. These words are bodily the same as entry 52 of list 1. Identical words in entry 52 of list 1, identical words in entry 33 of list 1. These words are identical to those, right?
It's referable to 52.
Right. Therefore, what does 33 say now? Let's read 33.
Trade and commerce in and the production, supply and distribution of the products of any industry where the control of, so scheduled industries, let me.
So,
Scheduled
what this
industry.
means is, the moment there's a declaration by Parliament under entry 52 of list 1, entry 33 of list 3 kicks in regard to trade and commerce, production, supply and distribution. So entry 33A in that sense is a carve out of entry 52 of list 1.
Look, may I put it slightly differently academically? This suits my eye.
Then we can't say that notwithstanding entry 33A, all these aspects, namely trade and commerce, production, supply and distribution, will still be under the exclusive domain of Parliament under entry 52.
Look,
They will still be under the domain of Parliament, but not an exclusive domain.
may I just point out, just examine this. This doesn't change my submission or.
That is what.
Let's suppose the constitutional framers have chosen to give concurrent jurisdiction on some aspects of a controlled industry under section 33. Lord, kindly visualize a situation academically to test the interpretation. Suppose there would not have been any entry 33, only entry 52.
It would all go under entry 52, undoubtedly.
Then, in that case, Lord, right from sourcing the raw material till distribution.
Absolutely. There is
The power.
probably you may be right.
Here, 33 is given with a view to see that under some circumstances, in absence of a law under 52, the state is also competent how to distribute, how to, etc., whatever, how to deal with the product. So, therefore, an additional concurrent power is given to the state. I may necessarily not depend upon 33. In absence of 33 also, the power would flow,
Under
Parliament,
entry 52.
52.
But when Parliament is enacting a law on the subjects under entry 33, we can't then say that law is relatable only to entry 52. Then it is within Parliament's legislative competence. Nobody can doubt that the IDRA is within Parliament.
I'm not.
But that part of the law then falls under entry 33. And then we have to see to what extent does that law exclude the power of the states, one, and to what extent that law leaves open some fields for the state. Because that what is left open to the states is after we look at Parliament's legislation. Parliament can legislate on everything under entry 33. We have to then construe that law, IDRA,
I bow.
the area which is left open to the states.
I bow.
If at all some area is left open to the states.
Please see page 10, Manoj.
Okay.
These are the 4 contingency I have formulated. When, a 52 law
The discussion on entry 33A by Dr. Ambedkar.
It's coming up, it's coming, Manoj, therefore. I have, my colleagues and we have worked it on that, on everything.
That will be very relevant.
Absolutely, but if your lordship permits, I may go chronologically, I have,
Sure, no
so that the flow is maintained. That's all.
Absolutely, you can.
So, when 52 kicks in, 33 we for the time being, post it as, on the side, for the time being. The activities of an industry or industries which affects the country as a whole. This is the first condition. Then second, it ought to be governed by economic factors of an all India import and cannot be permitted to be decided by state according to their provincial interests. Planning of future development and sound and balanced national perspective is required to be kept in mind, and to achieve inter alia the object of equitable distribution on pan-India basis at fair prices, the control of all aspects of a particular industry must be taken over. Parliament makes such statutory declaration in the Act. We hear, my lord, section 2. Now, my lord, please see para 10. Lord, this is IRDA, the introduction as given in the Act and the statement of objection reasons. Am I with your lordships at page 11?
Yeah, that.
On 6th April 1948, the central government announced its industrial policy, which was approved by the central legislature. Now, this is what was commented upon by one of the honorable members of the assembly, that this is not a correct policy, etc. As per the policy, the development and regulation of a number of important industries, the activities of which affected the country as a whole, and the development of which ought to be governed by economic factors of all India import, were required to be brought under the central control. This is what, my lord, the Parliament says. To achieve this objective, the IDRA bill was introduced in the state legislature. Then, my lord, SOR. The object of this bill is to provide the central government with the means of implementing their industrial policy, which was announced in the resolution number so-and-so dated 6th April 48 and approved by the central legislature. The bill brings under central control and development and regulation of a number of important industries, the activities of which affect the country as a whole. The entire activity, not manufacturing effects. Country as a whole, and the development of which must be governed by economic factors of all India import. My lord, the development would necessarily involve right from sourcing raw materials till distribution. It has to be done at an all India level with a national perspective in mind. The planning of future development on sound and balanced lines is sought to be secured by the licensing of all new undertakings by the central government. The bill confers on the government power to make rules for the registration of existing undertakings, for regulating the production and development of the industries. Please mark the word production, development of the industries in the schedule, and for consultation with provincial government on these matters. Provision has also been made for constitution of a central advisory council, prior consultation with which will be obligatory before the central government takes certain measures such as revocation of license or taking over the control and management of any industrial concern. Now, my lord, Constituent Assembly debates. Lord, this is the debate dated 5th January 1949. Shyama Prasad Mukherjee. Sir, when clause 2 was inserted as drafted, the idea of the government was that in respect of the entire concurrent list, it should be open to the Dominion legislature. Dominion would be, you mean, the Parliament, the corresponding legislature, to pass laws for the purpose of exercising executive function. At present, so far as the concurrent list is concerned, the Dominion legislature may pass laws which will supersede any laws passed by the provinces. But so far as executive authority goes, it can be discharged only by the provincial governments. In the new constitution under Article 60, which has already been adopted, it has been laid down that even with regard to the concurrent list, it will be open to the Dominion Parliament to pass laws for the purpose of exercising executive function. Well, I'm pausing here for a minute. The law made by the Parliament, implementation at the state government level. The Dr. Mukherjee says that he was also Dr. Shyama Prasad Mukherjee, that now for executive function you have carved out this, you have removed this exception. The question arose whether any such power should be taken over by the Dominion Parliament during the interim period. At present, during the Government of India Act, the Dominion Parliament and the Dominion Government can exercise authority in respect of matters which normally fall in the concurrent list in three ways. We have the Essential Supplies Commodities Act, which relates to certain specific commodities such as foodstuffs and certain other commodities in respect of which the Dominion Parliament and the Dominion Government have complete legislative and executive powers. The power will lapse in 1951. Now, please mark this. Secondly, we have a provision which lays down the development of industries which, in the opinion of the Dominion Parliament, is of all India importance, can be taken up by the Dominion Parliament. But that relates only to the development of an industry which may be so described by the Dominion Parliament.
Yes.
I'm sorry.
Actually, Dr. Shyama Prasad Mukherjee has made a very important point that control covers aspects beyond development.
Exactly. That's the respectful submission, which was initially, Manoj, in a different language accepted by Dr. Radha, that we are expanding the meaning of development by using the term control. I'm grateful, Manoj. But only one date your lordships may note, which I forgot. 31st August 49. Lord, the date may be noted, Lord, in the earlier submissions. Lord, when I read Dr. Ambedkar's clarification, is 31st of August 1949. The date may have some relevance because on that very day, the discussion about 33 also took place. Therefore,
What is the date?
31st August 1949.
31 August.
31st August 1949. So now I'll come back, my lord, to
In fact, my
page.
sister, Justice Nagaratna, said something very valuable, which is that she said that my learned sister said that control will include development and regulation.
Correct.
Both.
I'm grateful. Lord, I'm grateful. It's a wider term encompassing both. Lord, I was on page 12, my lord. We have Essential Supplies Commodities Act, which relates to certain specific commodities such as foodstuffs and certain other commodities in respect of which the Dominion Parliament and the Dominion Government have complete legislative and executive powers. This power will lapse in 1951. Secondly, we have a provision which lays down the development of industries which, in the opinion of the Dominion Parliament, is of all India importance, can be taken up by the Dominion Parliament. But that relates only to the development of an industry which may be so described by the Dominion Parliament. It has been felt that in respect of industrial development, it is not sufficient that Dominion Parliament or the Dominion Government should have power only for the purpose of developing industries which are deemed to be of an all India importance. Development has been interpreted to exclude regulation and control. What your ladyship says, which is negative, he is putting it negatively, that it excludes. development has been interpreted to exclude regulation and control of such industries and also trade and commerce in such industries, control of production and distribution of products of such industries. For that purpose, it was first thought expedient that wide powers might be taken by the Dominion Parliament even during the interim period by a suitable amendment of the Government of India Act. Apart from industrial development, there were certain other matters like statistics, censoring of films, and also industrial disputes in respect of which it was thought desirable that the central government should take adequate powers. So far as industrial and labor disputes are concerned, as has been explained by Sardar Patel, this is a provincial subject, but it has been felt desirable that there should be some uniformity of legislation followed by necessary executive action with regard to industrial tribunals which may be constituted under provincial laws for the purpose of settling disputes. After consultation with provincial government and some of the provincial premiers and representatives of provincial governments who were present in Delhi, it has been deemed desirable that during the interim period, completely wide powers need not be taken over by the Government of India, but a suitable amendment may be made only in respect of those particular items which are now of an urgent character and which require an immediate solution. For this purpose, you will find from amendment number 9 that we have referred to industrial and labor disputes, trade and commerce in and production, supply and distribution of products of industries and development of which is declared by Dominion law to be expedient in public interest. The sanctioning of cinematograph films for exhibition and inquiries and statistics for the purpose of any of the matters in the concurrent legislative list. This will mean a consequential change in clause 7 as originally provided in the bill. The later portion of clause A will be omitted and put in the concurrent list. Now please see, the result will be that so far as legislative powers are concerned, the Dominion Parliament will have ample powers to pass laws wherever necessary, and such laws will supersede provincial laws, if any. So far as the executive authority is concerned in respect of these matters, it will also be open to the Dominion Parliament to pass laws and take over responsibility for executive administration. In case such a step is considered to be desirable or necessary, sir, it is not intended that provincial government should not be utilized for the purpose of coordinating the policy of the central government, even in respect of those matters where central regulation and control are necessary in the interest of the whole country. Obviously, in normal circumstances, the executive machinery which will be utilized will be the provincial governments themselves. But if an occasion arises when it is necessary for the central government to exercise executive authority in respect of matters which are considered to be of an all India importance, power to do so have to be taken over by the Government of India and Dominion Parliament. A question has arisen whether this power should be exercised by the Dominion legislature without consultation with the provincial government. Hitherto, whenever the central government or the Dominion legislature had an occasion to take steps for introducing legislation for development of industries, previous consultation did take place with the provincial government. That was a conventional method, not a statutory mechanism. I believe on a suitable occasion, when the matter comes up a little while later, Sardar Patel will give an assurance on behalf of the government that during the interim period before the new constitution comes into force, if it is necessary for the central government to move in accordance with the powers which are now proposed to be taken under Amendment 9, previous consultation with the provincial government will always be held, and the result of such consultation will be placed before the legislature for information. Now, my Lord, Pandit Govind Vallabh Pant, he saws the seeds of 33A, if I may, my Lord, use that expression. Sir, all the four amendments, number 80, 84, 87, and 88, Lord, we have, in the footnote we have given, your lordships need not trouble, are interconnected and interlinked, and they must stand or fall together. According to the bill, development of industries where development under Dominion control is declared by Dominion law to be expedient in public interest, regulation and control of such industries, trade and commerce, whether or not within a province, in and production, supply and distribution of products of such industries were to be included in list 1. That is, all these subjects were to be brought within the exclusive jurisdiction of federal legislature and the federal government. Now that would have led to several other difficulties and complications. We all realize that so far as development of industries, where development under dominion control is declared by dominion law to be expedient in public interest, and regulation and control of such industries should vest in center. According to the entry already contained in the federal legislative list, development of industries where development under dominion control is declared by dominion law to be expedient in public interest is already included, and there is no intention of making any change so far as that is concerned. But as proposed in this amendment, regulation and control of such industries should also be placed under the jurisdiction of federal legislature. So far as the first two parts of this clause are concerned, they will stand as they are, but with respect to the rest, that is trade and commerce, whether or not within a province, in any production, supply and distribution of products of such industries, it is proposed by the series of amendments to which I referred at the outset that these should be included in the concurrent list and consequential changes should be made in other amendments. I think honorable members will agree that amendments that I am proposing will serve the purpose which the original clause had in view fully and will at the same time avoid other difficulties and complications which might arise if these items were not included in the concurrent list. For by including these in the concurrent list, the power is vested in the center to legislate with regard to these matters. Power is also vested by virtue of clause 2, which has already been amended to appoint agents directly for the administration of any of these subjects so that the center can have plenary, comprehensive, and if it so chooses, even exclusive control with regard to these matters. But whatever the center may do, I venture to submit that it will still be necessary for the provinces to exercise a number of functions within their own provincial boundaries with regard to these matters. So if these are made the exclusive charge of the center, then the provinces will not be free to discharge the duties and obligations which will necessarily devolve on them. In order to enable the provinces to play their part, subject to the overriding powers that will now vest in the center, it is necessary to include these items in the concurrent list, and that is what I propose. Even now, when we have got the Essential Supplies Act, the central generally frames a few basic rules and leaves the rest to the provinces. We in the provinces have been issuing orders, rules, and regulations with regard to these matters in our respective provinces. Whatever be the position hereafter, it will still be necessary for the provinces to exercise these powers. In our own province, for example, we propose to introduce a bill so that the distribution of building materials may be regulated, that no steel or iron or coal, etc., be supplied for the purpose of any building which is likely to cost more than rupees 25,000. The raw material for the building. That Pandit Govind Vallabh Pant Malot, subject to correction, was Chief Minister of Uttar Pradesh, the then United Provinces. second line, page 16. But I would like to be the cause of a laughter, not, my lord, the subject of laughter.
Here,
Yes.
when you give the example of sugar, control of sugar, and suppose the industries they divert towards preparing only alcohol, That example, did you pick up by virtue of you being a Gujarati or something?
Lord, Gujarat, Maharashtra
That's
and
right.
Karnataka, these are, my lord, the major sugarcane producing states.
Also, how much emphasis on sugar
Yeah,
and
yes, my lord. In
Sweet.
terms of, my lord, language as well as the food.
language? Yes, yes. Just wondering. So that discussion that was going on was on that only.
I am sorry, my lord. Sometimes, my lord, I'll just, my lord, on a lighter note, sometimes, my lord, listening to someone who is going on and on and on becomes boring. Once, my lord, in House of Commons, one honorable member started and he would never stop. And everyone was bored. And Winston Churchill desperately wanted to convey that now you are boring everyone. But how to say that? He immediately found one member in who was the listener using the hearing aid. So Churchill immediately interrupted the speaker and said that I want to know the name of this honorable member who is denying himself the natural advantage. He has the advantage of removing the hearing aid. Why is he not doing it?
But solicitor, we may accept your submission, we will not accept. But you are not boring because there is always a smile on your face.
I am grateful, Malad. I am grateful. Yes, yes.
And one more thing, after going through your entire submissions, ultimately it all revolves around Tikaram.
Yes, yes,
But
Malad. Tikaram.
Tikaram is wrong. Ultimately, you have to show that. But again, to create laughter, when you criticize Tikaram, you must remember that there is Ram in Tikaram.
Yeah, yes, sir. Tikaram ji, Malad. Everyone says Tikaram ji.
Has been
The entire submissions actually, it will boil down to that.
Correct. Keshav Ram also in the earlier matter. Yes, yes.
Consider Tikaram.
I will not be criticizing Tikaram ji, I will be criticizing the judgment. Tikaram ji was right in filing a petition.
Right, correct.
Judgment was not in his control. And what was argued, or more particularly what was not argued, was not in his control.
South we would have got.
But I'm on page 16.
No statement by Dr. Ambedkar.
No.
So in your note,
No, 33, something would turn.
right.
Now, kindly come to 16, only highlighted part.
That's correct.
Dr. Govind Vallabh Pant is advocating that provinces also must be having their say. They require a very extensive network, and I think it is not possible for the center to manage these things without the active cooperation and support of the provinces. So I propose that the amendment to which I referred at the outset be accepted unanimously. But this is how he saw the seeds. Now, please see, Lord, at the foot, I'm not going to read this. This is only for the purpose of completion. Evolution of entry 24 list 2. Industries except 52, to put it, to paraphrase it. Lord, it doesn't, assist your lordships or the other side either way. So, I'll not touch that. Please come to page 18, the evolution of 33. And that is crucial, Let me, go a little slowly. As I have said that I am giving 4 stages: devolution rules, Act of 1935, the draft constitution, and the constitution as ultimately, adopted. How it comes from central list to the concurrent list. That's the journey of 33. The predecessor of 33, with different language was in central list. But page 18, evolution and constitutional history behind entry 33, list 3. Then devolution rules. It was in entry 19, list 1. Control of production, supply and distribution of any articles in respect of which control by a central authority is declared by rule made by the Governor General in Council or by or under legislation by the Indian legislature to be essential in public interest. Lord, with change of words, it is substantially 52 plus 33. Now, my lord, in Government of India Act, it becomes like this. It comes in list 2 now. Exclusive state domain. Production, I'm sorry.
Yes.
Production, supply and distribution of goods, development of industries, subject to provisions in list 1 with respect to development of certain industries under federal control. Well, this came in list 2 in 1935 Act. It is substantially the predecessor of 33. That production, supply, etc., subject to list 1, which is under federal control. Now, draft by the drafting committee, my lord, page 19.
Yes.
Draft entry 36. Production, supply and distribution of goods. Even the draft constitution put it in list 2. Kindly mark that, my lord. The draft constitution also puts it in list 2. Now the Constituent Assembly debates. My lord, kindly, my lord, note here, I have forgotten to note, my lord, it is 31st of August 1949. When entry 58 was being debated, I'm sorry, when entry 52 was being debated, this was also debated on the same day. Nothing turns on that, but they had both scenario in mind. That's all. Shibbanlal Saxena wanted it to be shifted from list 2 to list 1. It was in the draft list 2. Shibbanlal Saxena, sir, I beg to move that after entry 64A of list 1, the following new entry be added. Regulation of trade and commerce in and of production, supply, price and distribution of goods, which are the products of industries whose regulation under the control of the Union is declared by Parliament by law to be necessary or expedient in public interest. Of any other goods whose regulation similarly is declared by Parliament by law to be necessary and expedient in public interest. Then he says, Sri Shibbanlal Saxena, here I would like to draw the attention of the drafting committee to the fact that a similar suggestion is contained in the recommendations of the Ministry of Industry and Supply, where they have suggested that in the 7th schedule in Union list, such an entry as I have suggested should be provided for. In fact, I may refer to the very page 14 of this booklet containing the comments of the various ministries on the draft constitution. There the ministry states, for effective implementation by the Union Government of the industrial policy announced by the Government of India on 6th April 1948 and for other reasons, it is necessary to invest the Union Government with certain powers over trade and commerce in respect of and the production, supply, price and distribution of goods produced by the industries to be brought under central regulation and certain other goods such as wholly imported articles or agricultural products. The following additional item is therefore suggested. Regulation of trade and commerce in and of production, supply, price and distribution of goods, which are, this is the government suggesting, the then government suggesting. The government is never the then, it's continuity. Of goods which are the products of the industries whose regulation under the control of the Union is declared by Parliament by law to be necessary or expedient in public interest. B. Of any other goods whose regulation similarly is declared by Parliament by law to be necessary or expedient in public interest. Sir, apart from the fact that this amendment has the support of Ministry of Industry and Supply, it should also be obvious to anybody that within the last 4 or 5 years, Our experience has shown us that unless there is this power to regulate trade and commerce and also production and distribution, there will be chaos in the country. Even the most important questions of supply of foods and food and clothing and other necessaries of life cannot be tackled on a mere provincial basis, and they must be tackled on an all India scale. So I say this power should be given to the union by means of an adequate provision here in the union list. Otherwise, the center will not have the necessary power. I think it is most important power which should be given to the center. Besides, Mr. President, will it suffice if I point out that there is a proposal for a new entry 35A in the concurrent list that covers this point? I think. Shibanlal Saxena, is it an amendment, sir? Yes, amendment number 142. Then T.T. Krishnamachari. That amendment covers the first part of the honorable member's amendment. Shibanlal Saxena, it is in the concurrent list, of course, but it is not as wide as one that I have suggested. I personally prefer this power to be taken over by center alone. President, very well. Shri Shibanlal Saxena, besides, the words that I have suggested give much larger powers to the center than it is proposed by the amendment in the concurrent list. I suggest the experience of our past 4 or 5 years is sufficient reason for taking this thing in the hands of the center. Sir, I do not think that we should be afraid of investing of center with power in regard to these vital things like food and clothing. Otherwise, I do not think we'll be able to meet the needs of the country in the manner we desire. At present also, the central government has got the power to lay down uniform policies in regard to these matters. But the center should also have the power to make all parts of the country to fall in line with the central policy so as to meet all the needs of the country. Then Honorable Dr. B.R. Ambedkar, with regard to the first part of the amendment, there is proposal of the drafting committee to put this matter in the concurrent list.
Yes.
And if my friend Professor Saxena were to examine the concurrent list, he will find that there is an entry corresponding to 64BA in entry 35A. 35A, my lord, is 33, present 33. Then, my lord, 35A, Honorable Dr. B.R. Ambedkar. Sir, I move that after entry 35 of list 2, the following new entry be inserted. Trade and commerce in and the production, supply and distribution of products of industries where the control of such industries by the union is declared by Parliament by law to be expedient in public interest. So this was accepted. So thereafter comes an amendment, my lord, in 1954. About 4 or 5 items were added. Apart
That
from
was Mr. Datar said because of Article 369.
yes,
So
yes.
for 5 years,
That
Parliament could
transitory-
control some other articles like cattle feed, raw cotton, jute. After
Because
that
it
5
was a-
years, the power would be.
369 was a transitory provision. Thereafter, my lord, this is read. But please see, my lord, the statement of objection reasons of that amendment, my lord. Constitution 3rd Amendment Act 1954, which amends entry 33. So they must be having a Herculean task, my lord. 1935, then transitory provisions to look at the future. Statement of objection reasons. Entry 33 of the concurrent list enabled Parliament to legislate in respect of products of industries declared to be under the union control. In addition, Parliament was empowered by Article 369 for a period of 5 years to legislate in respect of certain specified essential commodities. It was not considered advisable that after Article 369 lapsed on 25th January 55, the center should be divested of all legal powers to control the production, supply and distribution of some of these essential commodities. Specifically, my lord. Then, my lord, addition I may not, my lord, read. Now, my lord, kindly see page 23, because the respectful submission of the other side was about entry 8, list 2, intoxicating liquor. What it means, my lord, the last line first, it only means a beverage having the effect of intoxication. And when we say intoxication, we necessarily say of human being, which is capable of being consumed as it is. If I buy denatured alcohol and do some activity, do some process in it and make it drinkable, it might give me an effect of intoxication. But that is not what is meant in entry 8. It's beverage meant for human consumption for the purpose of intoxication. Two caveats before I will go through that. Number one, what is the import of entry 8 is not a question referred. But when I am before a bench of 9 honorable judges, I can't stand on that technicality. And in any case, the Lordship will have to examine 8 to answer the questions, whether specifically referred or not. And therefore, I have answered it fully. Number two, here, your Lordships are aware, for any product, there are two categories of entry. One, general entry, another, taxing entry. Here, we are not concerned with the taxing entry. They have also not argued, and that's not the question arising. Whoever is taxing whatever, my lord, that continues. Now, my lord, page 23, somewhere in the middle, entry under the devolution rules. Entry 16, provincial subject list. My lord, it was in list 2, my lord, in the present parlance. Excise, that is to say, the control of production, manufacture, possession, transport, purchase, and sale of alcoholic liquor and intoxicating drugs. This is an entry, taxing entry, but we are just trying to understand what constitutional framers understood when they say intoxicating liquor. One thing
Yes.
One thing your lordships will find as a thread historically, that alcoholic liquor is always spoken of along with other drugs, opium, poison, etc. So in a negative sense, it was considered to be a vice rather than a product. Lord, with respect, Lord, this is what comes out. This is not my personal view. But that is how, my lord, it comes out. So, excise, that is to say the control, production, manufacture, possession, transport, purchase and sale of alcoholic liquor and intoxicating drugs. My lord, intoxicating drug can be bhang, which comes, my lord, subsequently by name, my lord, Indian hemp. And the levying of excise duties and license fees on or in relation to such articles, but excluding, in the case of opium, control of cultivation, manufacture and sale of export. So all consumables, alcoholic liquor and intoxicating drugs, which were, opium is also an intoxicating drug, which was excluded. Now, the above referred entry makes the following apparent. Entry 16 in devolution rules is a combined entry both for taxing and other purposes. Lord, thereafter, there is a distinction. But I'm sorry, my lord, kindly pause here for a minute. So far as this entry is concerned, it is a combined entry for regulation as well as for taxation.
Yes.
which, my lord, gets bifurcated subsequently. Second, at page 24, it covered both potable and non-potable alcohol, and therefore there was no distinction between alcohol for human consumption or intoxicating alcohol and alcohol on one side and remaining alcohols, that is non-potable alcohols, on the other side. Alcohol as a generic word, along with its taxing power, was a subject in the state list under 1919 devolution of devolution rules. Alcoholic liquor, my lord. Now, my lord, kindly come to page 24, para 23. My lord, again, my lord, taxing entry, but now it is split in three heads. My lord, two are taxing and one is general. I did not, my lord, elaborate much on taxing entry being different from general entry. Hoyt's and other judgments are very clear, my lord. Lord, this would, I'm sorry, ma'am.
Yes.
Lord, this would also give your lordships, my lord, an assistance. Your lordships would have noticed in some of the entries, no, there are two words used, two expressions used. One is intoxicating liquor. And in taxing entries, the expression used is alcohol fit for human consumption. Alcoholic liquor for human consumption. Why? We were just wondering why. There are two expressions used, but I'll come to that. Now, my lord, Government of India Act 1935, entry 45, list 1. Now, my lord, it comes in list 1, that is the federal government, the central government, so to say, my lord, in present. Duties of excise on tobacco and other goods manufactured or produced in India, except, now this comes in the exception and therefore goes in second list. So tobacco is central subject. Now please see the expression alcoholic liquors. I'm sorry.
Yes.
First is, kindly see the expression alcoholic liquors for human consumption. Then second, opium, Indian hemp. Lord, Indian hemp is bhang. And other narcotic drugs and narcotics and non-narcotic drugs. There are some other non-narcotic drugs having the effect of intoxicating you, but not falling strictly within the definition of narcotic. Then C, medicinal and toilet preparations containing alcohol or any substance included in subparagraph B of this entry. Now, my lord, please see Government of India Act. It is apparent that for the first time, alcoholic liquor for human consumption and other alcohol were bifurcated. For the first time, this bifurcation takes place, which remained till date, my lords. 2. So far as non-potable alcohol is concerned, it was shifted to list 1 as entry 45 of Government of India Act, which is clear from the expression except. Lord, kindly pause here for a minute. Alcohol for human consumption is taken out of entry 1 and given to the provincial entry list 2. Meaning thereby, alcohol not for human consumption, that is non-potable alcohol, is with the center. Now comes, my lord, corresponding entry, my lord, in the state list for taxing purpose. We are not concerned with the taxing power, my lord. I am not arguing taxing power. I am just showing the evolution how that word is understood. Intoxicating liquor and alcoholic liquor for human consumption. Entry 40, List 2, Government of India Act. Now this is for Malord, List 2. So state has this Malord. Duties of excise on the following goods manufactured or produced in the province and countervailing duties at the same or lower rates on similar good manufactured or produced elsewhere in India. A. Alcoholic liquors for human consumption. It goes in the state list. According to me, even today, this is there in entry 8, with the state, there is no dispute. Non-potable liquor is with the center. That's my lord, what ultimately, my lord, I would like to assist your lordships. And similar, my lord, opium, Indian hemp and other so and so, so and so, so and so. All these three exceptions are now in the state list. Para 26. Lord, I can skip that, my lord. Now please come to page 26. How the drafting committee, my lord, drafted this. Duties of excise
Yes.
duties of excise on tobacco and other goods manufactured or produced in India except alcoholic liquor for human consumption. Please note, my lord, this is a taxing entry and therefore the Constitution uses the expression alcoholic liquor for human consumption. B. Opium, Indian hemp and other narcotic drugs and other non-narcotic drugs, but including medicinal and toilet preparations, etc. Now, draft entry 52, list 2. Duties of excise on the following goods manufactured or produced in the province. There were a distinction earlier that produced in the province and other than province. Purpose of showing this history is to show that what is intoxicating liquor under entry 8 has always been with the state and non-potable has always been with the center.
But taxing of potable alcohol is with the center.
Yes, that comes.
State.
Non-potable, non-potable.
No. Taxing of alcoholic liquor for human consumption, that is with the state.
Yes,
That is with the state.
because it's for the human consumption. But non-potable, by its very definition, not consumable by the humans. You may add something, you can make something, that's not for human consumption. You are forcibly making it for getting intoxicated.
So far.
Now, para 27, my lord, on page 26.
Taxing is now.
Your lordship, I'm sorry.
26?
Page 26, para 27.
Yes.
From the aforesaid, it is clear that entry 45, list 1 of Government of India Act was renumbered as entry 86, list 1, as is existed when Constitution came into force. But I'll show subsequently it is amended. Then entry 40, list 2 was renumbered as entry 52, list 2. That is, my lord, similar provision for taxation. 86 is central government's power of tax. 52 list 2, this is not 52 list 1. 52 list 2 is similar power of taxation by the state government. In the Government of India Act, the federal government had no jurisdiction over medicinal and toilet preparations containing alcohol, etc., as per clause C. In the draft by the drafting committee, the said exception was removed, meaning thereby the central government was conferred with the power to levy excise on medicinal and toilet preparations. Now come, my lord, 84. This is pre-amendment. So this is now a constitutional entry. I'm not going into, my lord, I have already shown the history.
Right.
Devolution rules, 35, draft, etc. Now, my lord, this is list 1, entry 84. To give, my lord, what is meant by the alcohol for human consumption and intoxicating liquor. We are not concerned with the taxing entry, but this we get the clue from the taxing entry. My lord, list 1, entry 84 says duties of excise on tobacco and other goods manufactured or produced in India except A, alcoholic liquors for human consumption. So taxation power goes from center. For alcoholic liquor, human consumption, that is potable alcohol. And I'll say why. I'll show why alcohol liquor for human consumption is potable liquor. And second, why in taxing entries it says alcoholic liquor for human consumption. There is a reason. Then B, opium, Indian hemp, and other narcotic drugs and narcotics, but including medicinal and toilet preparations containing alcohol or any substance included in subparagraph B. Lord, now, Lord, in 2016, this is only for completion, nothing turns on that, but I may not be accused of not pointing out. Either way, my lord, against me or for them or against them or for me, nothing turns. But in 86, this 84 is amended in 2016, where this alcohol is deleted. Because now it is gone in GST regime, therefore. Not that central control is deleted, but it's in a different regime with which we are not concerned. Now, page 28, entry 51, list 2. Now the taxation power of the state. Earlier, your lordships have seen, my lord, unamended entry 84, except alcoholic liquor for human consumption. Now it says for alcoholic liquor for human consumption. So page 28, entry 51, list 2. 51, taxing entry of 51, of list 2. Duties of excise on the following goods manufactured so and so. A, alcoholic liquors from human consumption. It was removed in 84 from the central list at the time of the constitution itself and brought within the taxing power of the state legislature at the time when the constitution came into force. Well, there is one important entry. I just make a mention which will assist your lordships, my lord. That is entry 54, list 2. This has undergone an amendment.
Constitution then brings in entry 51 of list 2.
Yes, ma'am.
Alcoholic liquors for human consumption.
For taxation purpose.
Yes.
It's a fiscal, but a taxing entry.
And then you have entry 84, which was a corresponding entry.
Yes, my lord, corresponding is the correct word, my lord. I was searching for that word. 84 and 51 are corresponding entries, respectively for center and the state.
Yes.
So entry 54, list 2, prior to amendment. Again in 2016, it is amended because of GST regime. Taxes on, this is pre-amendment, taxes on the sale or purchase of goods other than newspapers subject to provisions of entry 92A of list 1. Now, my lord, in 2016, taxes on the sale of petroleum crude, high-speed diesel, motor spirit, commonly known as petrol, natural gas, aviation turbine fuel, and alcoholic liquor for human consumption, but not including sales in the course of interstate trade, etc., etc. So again, my lord, alcoholic liquor for human consumption comes in. But I leave it at that, my lord, nothing much turns on that. The bottom line is that alcoholic liquor for human consumption is used in taxing entries. And entry 8 list 2 is different. Now, my lord, please see evolution of entry 8 list 2. This was, my lord, the quintessential debate, my lord, which took place. Lord, what was the position in Government of India Act 1935? Lord, there is no similar corresponding provision in devolution rules. I'm sorry. Where is that? My lord, it was quoted, my lord, at page 23. Para 21, my lord. I'm sorry, my lord, I stand corrected. I'm thankful to my learned friend. It was my lord, I pointed out, it
It is a new topic now. Should we begin after lunch? Because this is really now coming into the heart. We've seen now the broader taxing entries use the expression alcoholic liquors for human consumption.
Please.
Because the heart of their submission is entry 8. Therefore, we just want to have
Yes,
a little bit of time to reflect on what you argued earlier.
Yes.
We'll return at 2 o'clock.
There are other issues also I would like to address, but we are now on entry 8, certain.
Also on the interpretation, Mr. Mehta,
Yes, ma'am.
intoxicating is the key word, right? So we have a kind of people who has great capacity to consume. They never sort of get intoxicated.
What is the level
Will the interpretation differ depending upon the personal
capacity?
to
It should, my lord. In fact, the Constitution has not taken care of that.
But I shall not fall for that trap, Lord.
My learned friend seems to have a larger capacity. And then
Both the phrases is the word liquor.
liquor.
One is intoxicating, the other is alcohol.
And human consumption.
Yes.
So you have to explain the difference between
Yes, yes.
two intoxicating liquor and alcoholic liquor.
Yes.
What is the difference between the two?
And why the word human consumption is used only in taxing entry.
That's right.
That is certain.
Don't
So
get
this is a classic
intoxicated.
case where non-taxing entry becomes more taxing.
Yes, for the my lord God. Yes, your lordship are right.
That is what is on.
Shastini.
Obliged. I was on page 28.
We'll get better stools for your juniors on Monday.
But
It's only
were
for today.
discussing-
If it could bear my weight, I think it can bear your weight because my weight does a little more because I don't run around as much as your juniors. But
Lord, weight going by, not the physical weight, my lord.
I'm talking of physical weight.
Because, my lord, sometimes we have seen your lordship's portion of foods, my lord. So, yes, weight, yes, but not physical weight. My lord, but we are
It's nice that
grateful.
they all
My lord, we were
speak, right?
discussing that only, my lord. That's really, my lord, a great gesture, my lord. We are immensely grateful. Lord, page 28.
Sorry.
But here, so far as entry 8 is concerned, the Constituent Assembly debates does not throw much light. But I want to show, my lord, those 4 stages again here also to show how this was clubbed, with what products it was clubbed. But at the foot, Government of India Act 1935, Lord, I have shown the devolution rules had both the entries, taxing and regular entry. intoxicating liquors and narcotic drugs. That is to say, the production, manufacture, possession, transport, purchase, and sale of intoxicating liquors, opium, and other narcotic drugs, but subject as respects opium to the provisions of List 1 and as respects poisons and dangerous drugs to the provisions of List 3. But then draft of by the drafting committee. Intoxicating liquor and narcotic drugs, well, substantially the same. Your lordships may consider avoiding that, ignoring that. Now kindly see, my lord, draft entry 40 was placed before the Constituent Assembly. There is a short debate on the same on 2nd September 49. It may, however, be pointed out that the debate dated 2nd September, on which entry 8 list 2 came to be finalized, had a tremendous impact of the earlier debate dated 19th, 23rd, 24th, November 48, while introducing Article 47 as one of the directive principles of state policy. The debate which took place regarding draft entry 40, list 2, that is present entry 8, is as under. My lord, your lordships can skip. Nothing much will assist your lordships, my lord. Now, Lord, kindly directly come to page 31. Lord, there is the very extensive debate preceding Article 47, Directive Principles of State Policy. Lord, one of the honorable members on the lighter side, and he says this. He said that I have never spoken in my life. I never used to participate even in debate competitions. In this Constituent Assembly debate also, I am speaking for the first time. But I feel so strongly that I want to speak. So there is a detailed debate which I have not quoted. I have annexed so that your lordships can get the immediate reference. Duty of the state to raise the level of nutrition and the standard of living and to improve public health. The state shall regard the raising of level of nutrition and standard of living of its people and improvement of public health as amongst its primary duties, and in particular, state shall endeavor to bring about prohibition of consumption except for medicinal purposes of intoxicating drinks and drugs which are injurious to health. The Honorable Court would notice, and your ladyship remarked, that here the word used is intoxicating drink, because the Parliament wanted to give a little expansive meaning, because apart from intoxicating liquor, there are drinks like bhang, etc. Therefore, my lord, it's an expansive meaning. Now, my lord, this is considered in one judgment where your lordship's court, my lord, quotes Sirvai. Please see, my lord. The importance of Article 47, this is Ashok Lanka versus Rishi Dikshit. The importance of Article 47 of the Constitution may have to be noticed, tracing the history back from the date of constitutional debate. With a view to find out the intent and purpose for which the said provision was inserted, Sri So-and-so noticed that all sections of the society, including Mohammedan community, whose social habits were reinforced by the Quranic injunction in relation to intoxicating liquor, supported the insertion of such a provision. Consumption of intoxicating liquor in Quranic culture can never mean non-potable. It has to be potable liquor. The prohibition of intoxicating liquor had long been a part of the policy of Indian National Congress. Congress would never have a policy for non-potable industrial alcohol. And its inclusion in Article 47 received support from the Mohammedan community whose social habits were reinforced by the Quranic injunction against intoxicating liquor. In considering the directive in Article 47, it may be observed that the alcohol, the intoxicating ingredient of liquor, is a narcotic, a word replaced by the word depressant to describe the same effects, contrary to the popular belief that it is a stimulant. It is not mere accident that intoxicating liquor and dangerous drugs have been clubbed together in entry 8, list 2. This is, my lord, commentary of Honorable Sirvai, my lords. Lord, please come to, my lord, now the main question, my lord. Why there are two different expressions used. Lord, I'll read 3 or 4 paragraphs, but my lord, just let me paraphrase my submission. So far as entry 8, list 2 is concerned, my lord, prima facie, textually, contextually, it means, my lord, a beverage which can be consumed, which has the effect of intoxication. The Parliament is not concerned with the intoxicating effect which the person will have or will not have, or it is alcoholic, etc., etc. Therefore, with a view to ensure that the legislature providing for the taxation of non-potable liquor can decide the incident of tax. But it is not saying intoxicating liquor. My lord, kindly in this context, please see para 32, para 35 and page 32. That's the only distinction, my lord, which we can get. These words,
But one way I
expressions.
have to look at it, in support of what you are saying, which is that alcoholic liquor for human consumption is a species of intoxicating liquor. Right? So, intoxicating liquor will include a variety of products, a variety of products, I'd say, of goods, including alcoholic liquor for human consumption. When the legislature imposes a tax, it has to impose a tax with clarity. Therefore, they identify the product itself, namely alcoholic liquor for human consumption. When it comes to the regulatory power of the state, that regulatory power of the state under entry 8 is couched in much wider terms than the taxing power, for the reason that when you regulate both what is legal and what is illegal. So, the idea of conferring the power on the states to regulate intoxicating liquor was to allow them to also deal with
After effects, social effects, etc.
and where the intoxication may not be due to alcohol, but non-alcoholic intoxication also in that liquor. So, the alcoholic content of the liquor may be one source of intoxication. But to give regulatory, suppose they were to use the expression instead of intoxicating liquor in entry 8, suppose they were to use the expression alcoholic liquor, the states would not have the power to deal then on a regulatory basis with other things which are not exactly, which are not alcoholic, but which are intoxicating nonetheless. So the regulatory domain of the states was widened as compared to the taxing domain, because the taxing domain has to be always extremely specific, because you have to specify what is the taxing event.
I'm grateful, my lord, that I could not have put it, my lord, that more succinctly than that. For example, my lord, for regulating the consumption liquor, the liquor which is meant for being consumed, the state may need several regulations. Don't drink in public in some circumstances. Don't do certain things, etc., etc. And we trace the history in Britain, because ultimately a 1919 Act, 1935 Act had an impact. We were a British colony. And even in the Constitution, so far as some expressions are concerned, it has the British imprint.
Overflows are not.
अभी आता है
Liquor is much wider than alcoholic liquor.
yes.
That's
That is
that's
one.
what you are driving at.
Yes, brother. Number two, while providing for a taxing entry, the taxing statute will have to define the incident of tax. For example, excise, when the liquor is manufactured, which liquor? Liquor which is ultimately going to be used for human consumption. For example, under entry 52 list 2, taxing power of the state, same expression. Alcohol, liquor for human consumption.
So it specifies the taxing event.
Taxing
It
event,
is alcohol,
incident
but
of
it is defined with the reference to the purpose.
yes, purpose, and it necessarily involves human being because the word intoxicating means someone is getting intoxicated. Here, for the taxation purpose, it's not necessary. You manufacture alcohol, whether it is potable or non-potable, the taxing event takes place. Whether it may be consumed, may not be consumed, it may have X intoxicating effect, Y intoxicating effect, the taxing statute is not concerned. Therefore, it is only in the taxing entries that the word alcohol for human consumption is used. That I am manufacturing, I am liable to excise. I am selling at this point of time when the sale, your lordship knows about several judgments, whether sale takes place at the time when the contract is entered into, or when the delivery is done, or the when sale is complete. That's a matter of separate argument in taxation. But then for defining incident of tax, they put it in a general way that whenever you produce alcohol for human consumption, this is the incident of tax.
That is the end use of that product.
Is
Is
it
the basis.
if it is to be regulated other than tax, fiscal regulation, then entry 8, list 2,
But for taxation, it is the end use of that product
which is relevant. Yes.
which is relevant.
It's yes. But at what point of time it becomes taxable? That is entry 86 and 52, respectively of list 1 and list 2.
But, you know, just as Brother Oak said, intoxicating liquor is wider than alcohol for human consumption. But according to you, even in the intoxicating liquor, it has to be something which is intoxicating to a human being.
That is, yes, has to be methods. Because the word intoxic, otherwise it loses its meaning.
That's right.
Not necessarily alcohol. For instance, you know, you have all these classical cases on somebody being inebriated with the distilled essence of mahua flowers,
Yes.
right? Locally, they taught that case to us when somebody was, you know, but so that is not alcohol. I'm not conversant with it. I may be wrong.
My lord, mahua
not
is
sure-
the raw material for an alcohol.
But mahua flowers per
In
se is not
Gujarat, my
alcohol.
lord, it is quite,
But you can still regulate it as can you regulate it as intoxicating
yes,
liquor?
mahua, yes, mahua, yes. No, not mahua flower per se, but mahua alcohol, mahua liquor. It is, mahua is converted into liquor.
Into alcohol.
Supposed to be stronger than the regular liquor, my lord.
So what are those intoxicating substances
Bhang,
which may
my
not
lord,
be
for example.
alcohol?
Bhang, my lord, for example.
Bhang does not contain alcohol. Bhang does not contain alcohol.
No, bhang does not. It contains some narcotic substance. It's a non-alcohol, it's non-alcoholic intoxicant.
It's not liquor.
Not liquor. It's not liquor.
Lord, bhang is a separate item even for excise.
Yes.
It is
Not a liquor.
Yes, yes, it is uncontrolled. Bhang is the worst intoxicant.
In Lordship goes to Concurrent also, to take the coconut trees, tadi which we get.
I was just going to ask Tadi, Nira.
Nira, yes. After evening, Nira becomes.
Toddy. These are what's called self-generating alcohol in kashayams and all in Ayurvedic medicines. Alcohol itself by internal fermentation is generated.
So for instance, in Kerala, if you go to Kerala or even Goa, in the evening, there's somebody will come to the coconut palm, climb up in a moment and get you the toddy. You have it. It's very extremely pungent, but it's not alcoholic.
No,
You
it
keep it in the morning,
becomes
it
by the
becomes
evening.
alcohol.
Keep it for the day.
It becomes alcohol.
It becomes after in the
When
evening.
it's pulled down from the tree, it's tapped from the tree, it's not alcoholic.
No, it's
You
not.
may still not be able to have it because it has a very distinct odor.
As the
But
day
it's
goes
not
by-
alcoholic at all.
No,
As the
therefore,
day
the
goes by,
tadi shops are
fermentation makes it
fermentation takes place, then it becomes alcoholic.
yes, tadi shops are closed after afternoon.
So many times
Because
on the
it
highways in
starts
Maharashtra,
getting
you will
fermented.
find these little steel kiosks which say, Yete Nira Vikrila hai.
So Nira becomes Madi, then Madi becomes Tadi. That was I was told in Kokan.
No, even in UP, Lord, Nira is had in the morning.
He is right. Mr. Datar is right.
So even in our younger days, we used to go to the village. You get morning Nira, it's quite tasty and fresh. But
Yeah, even-
when it's fermented, it becomes more and more.
So therefore, Gujarat being a prohibited state, all Nira shops are closed after 2 o'clock because then it start getting fermented.
Fermentation process starts.
But that is alcohol.
It becomes
Yes.
alcohol.
It becomes alcohol.
Intoxicating.
Lord, now, my Lord, I may show some history.
They will not permit you to carry.
Even we have it today. Toddy or Nira seems to be little intoxicating. Lordships were so deeply engrossed in the discussion of Nira.
We are discussing how toddy is added to appam to make it fluffy.
But toddy, my friend said during my young days we used to have it. Not, I think that is wrong. Toddy even had today, Lord, is delicious. I mean, sorry, the Nira.
Nira.
It's
In the morning,
delicious.
yes.
Yeah, it's delicious. And it's healthy. They say it's healthy.
Delicious is a subjective thing, but yes, it is healthy. No, sir. It's pungent. But
No, Nira is not.
Nira is not.
What Mr.
Nira is
Dwivedi
like
saying that,
earlier,
what Mr. Dwivedi is saying that even Solicitor General can have Nira. You see.
Yes.
Is not toddy.
Toddy is Punjab.
Toddy is.
But he talks of alcohol.
Yes, Nira is not
elsewhere.
toddy.
My friend talks of alcohol. He recites couplets also about alcohol flowing from the eyes, perhaps.
Para 42, kindly see, one of this argument.
The only point which they have been trying to make is that the word intoxicating per se does not exclude intoxicating liquor which is not for human consumption. That's their case. So
That is para 42. I wanted
Para
your
42.
lordships- Yes, because it should be consumable. You cannot make it drinkable. It has to be a beverage.
para 42.
42, my lord, at page 34. Secondly, the term intoxicating liquor would necessarily mean a product which can be taken as it is, by which one gets the effect of intoxication. It may be possible that some form of industrial alcohol, that is non-potable, may bring the effect of intoxicant if diluted or mixed with some other chemical or taken in a particular manner. Entry 8 list 2, however, consciously covers the field for a product which is capable of being consumed as it is for bringing the effect of intoxication, and not something which is not an intoxicating beverage but has the potential of being converted into an intoxicating drink. But you can't go into the market and say that give me denatured spirit or give me ANA and then mix it with something or dilute it with something. It has to be consumable as it is, as a beverage, which gives the effect of intoxication to a human being. Otherwise, my lord, there is impossible to reconcile this, my lord. That center has non-potable, state has potable.
Our mind gets in.
But 43 also. Para 43 at page 35 also, my lord, I have given the distinction that something can be used, something can be abused. Please see, my lord. It is submitted that as far as possible, a common parlance understanding and meaning shall have to be given to the expressions used in the Constitution. The common parlance understanding of the expression intoxicating liquor is an intoxicating beverage containing liquor and having the effect of intoxication, and merely because some other form of alcohol, that is, industrial alcohol, etc., can be abused for getting intoxicated after making some changes in the composition, would never be falling within the meaning of entry 8 list 2. And there is a reason, my lords. There is a reason. Lord, entry 8 is a regulatory entry. Suppose we read in intoxicating liquor, even non-potable alcohol. Lord, would the state, I'm posing a question to myself, regulate that when you buy non-potable alcohol, namely ANA or any industrial alcohol, I hereby regulate, don't add more than 30% weight for volume water or add more than 50% volume per water. That's not regulation contemplated.
But there's only one area, Mr. Solicitor, one area, just consider it. Suppose there is some kind of, and there is now as we know, intoxicating liquor, industrial alcohol, or I can say denatured spirit. Industrial alcohol is an inappropriate phrase. Denatured spirit, which can, and we know that it can, be converted into intoxicating liquor, either by a process or by whatever. Now, if that possibility of abuse is there, can we deny to the state its regulatory power to ensure that the abuse does not take place? I'll tell you why. Center is a center is, I mean, it's not pejorative. Center is a disconnected entity from the states. You're a national entity. You're not going to control, what's happening in every district, in every collectorate. Suppose there is a strong possibility of denatured spirit being misused for the purpose of consumption. State is vitally concerned as the custodian of public health. I don't want this liquor tragedy to take place within my jurisdiction. So state can impose regulations for ensuring that abuse does not take place. If we concede to that state the power to regulate for the limited purpose, even assuming you are right, that entry 8 covers only intoxicating liquor and liquor which is therefore intoxicating for human consumption. The state is still keen on ensuring that somebody else does not use a product which may be of grave danger to public health by misusing the nature of the product. They can make regulations limited for that purpose. And as an incident of making regulations for that purpose, why should we deny them the power to impose fees for that purpose?
Not fees, my lord. The regulatory power, my lord, would be not to consume that, my lord. And
not to consume it, or for instance, you must, if you are transporting denatured spirit, that you must have whatever passes, licenses, or that you will transport it under certain conditions, declaration in a certain form, variety of regulatory programs.
that can be done by the center. I'll show, my lord, from IDR Act. That is what is contemplated. For so far as
Can the state not also say, look, this is happening within my territory. This is likely to affect, and we now know that these tragedies, Hush tragedies and all these tragedies
which
take
is
place.
different, my lord.
No, I'm just giving you an
Yeah.
example that these tragedies do take place. The states are vitally concerned with the health of their citizens. Now, why should the state not have the power to just regulate? And if they can regulate to ensure that there is no misuse, then you can impose any fees as an incident of your power to regulate.
Health is a separate entry 26, entry 6 in the third list, in list 3, in the second list. But maybe in that exercise of that power they can.
Exactly.
But so far as the industrial alcohol, non-potable is concerned, the regulation under the IRDA will have to be made by the center. Maybe delegating the exercise of powers to the state. That these are the statutory regulations. Every company manufacturing denatured alcohol will have to get this much these many registers. It will have to make entries. It will have to sell it only to authorized dealers. It will have to ensure that it doesn't go to unauthorized hands. Your police officials will ensure that it is not being used for the purpose of converting clandestinely into something which gives intoxication, etc., etc. But the law will have to be, in my submission, traced under Malot 52, because it is non-potable alcohol. It will not fall within 8. And Malot, this is how the drink is treated. Intoxicating liquor is treated historically, and that in a short while, I'll just give, if your lordships can come to page 35. How, my lord?
Solicitor, it was argued that denatured spirit can be converted into something which can be consumed. It becomes intoxicating liquor. So, state has power to legislate for regulating something which is prepared by using denatured spirit. Suppose denatured spirit is converted by some process into intoxicating liquor. That aspect can be also regulated by the state government.
I'm sorry, my lord. The argument is fallacious. Denatured.
So firstly, tell us whether it is possible to convert denatured spirit into a intoxicating liquor.
That argument I'm respectfully submitting is fallacious for the reason denatured alcohol without any industrial process, by some clandestine process, can never be converted into a consumable product. It is converted into a product which gives you intoxication. But for example, snake bites in a limited quantity gives you intoxication. Some cough syrups have alcohol content, more alcohol content. People drink the entire bottle and get the intoxication. This is an intoxicating drink, but not permitted. When you convert in clandestinely, what they do in the breweries, they convert industrial alcohol into potable alcohol, but by way of methodology, by way of machines, by way of controlled environment, by way of a particular temperature being maintained, etc. And the purpose is to create alcohol, the beverage for human consumption. What we are discussing and what my learned friend was giving an example, it is capable of being converted, meaning thereby we can add something and we'll get intoxicated. But that is not intoxicating liquor. You are clandestinely misusing the product with a view to ensure that you get
It's
intoxicated.
a regulatory entry structuring the regulatory power of the state. So when entry H says intoxicating liquor, it would be very restrictive for us to say that this will apply only to properly so-called intoxicating liquor. Why cannot it extend to regulating those products which are misused for the purpose of selling them off as intoxicating liquor? Because, because then what we'll be doing is we'll be telling the states that, look, you can't do anything, even though there's a grave danger that this would be used for the
They can
purpose
do
of,
many things. I'll show.
but under the central law, you are saying.
No. Even under the state law. Please see, my lord, how this history has developed. How United Nations used to and still controls the word intoxicating liquor. My lord, we have derived the imprints of this expression from United States.
Therefore, you concede
United.
you concede, therefore you accept, not concede, you accept that the states do have the limited power, whatever that powers we'll see, to regulate.
For health. If Hooch is different. Hooch is completely different, my lord. It's kind of a unauthorized small brewery. What my learned friend is talking about is that I buy denatured spirit, adds water into it, and if I drink.
Constitution. I have, yeah. Yes. So
I buy the.
You talked about clandestinely made intoxicating liquor. So if it is a clandestinely made intoxicating liquor, it will be entry 8.
No, my lord, it would be health, law and order, etc.
Because
Intoxicating liquor means pure and simple beverage manufactured, commonly used for the purpose of serving to people. We will have to give that meaning. Otherwise, there may be several.
But it will also cover those liquors which are passed off as intoxicating liquors, because they have a deleterious effect.
They can't cover
Entry 6
exception.
and entry 8 of list 2 are not in that sense disjunctive entries. They are both, the state has both powers under the domain under entry 6 and the domain under entry 8. Entry 6 says public health, entry 8 says intoxicating liquor. Why can't the state say that, well, we are concerned about the fact that there are products in the nature of denatured spirit which are being passed off as intoxicating liquor, and we want to prevent that happening by having regulatory measures in place
Then,
limited to that purpose.
one way of interpreting is
entry 6, my lord, entry 6, even law and order. Even law and order. The reason I'll tell you, Lord.
But once we accept that the states can do it, whether it's under entry 6 or entry 8, it makes no difference.
No, I am protecting 52.
Incidentally, entry 6.
It is entry 6 only.
But I am protecting 52. Sum total would be sum total, I'm sorry. I'm going to say that. Share your lordship's concern that so far as the effect of an abuse is concerned, the state would be more concerned in regulating that. Lord, let kindly examine, my lord, from another angle. What would be the constitutional position, my lord, if that view is taken? That's my respectful submission. My lord, one thing is clear, if I am right, that non-potable liquor, the regulation is with the center. Potable liquor, regulation is with the state. That's the constitutional position. Now, your lordships, by a judicial verdict, create a third category that any abuse of non-potable liquor as potable liquor will go to the state, which would amount to amending the entry.
Take a case of, say, the state of Gujarat or the state of Bihar.
Yes.
They have imposed prohibition. They have a policy of prohibition.
Yes.
No liquor consumption, no consumption of liquor or alcohol for potable purposes.
Yes.
That is completely, therefore, outlawed within the state. If we accept your very rigid classification, that would mean that much as though these two states have imposed a policy of prohibition, you cannot control the inflow of this clandestine trade in, say, denatured spirit or industrial alcohol, which is capable of being and is being used for the purposes of
that is not a practical way of looking at it, but not kindly see where do we stop. If that is so, the state can, if that is right, then the state can legitimately say that non-potable alcohol which is manufactured in Gujarat or Bihar, also we will control that it has to have a particular degree of alcohol so that it is not abused. Then they start regulating the manufacture also. How do we define the abuse? Because maybe at some percentage of alcohol, in the denatured alcohol, it is either easily possible to abuse or it is difficult to abuse. Then, my lord, they can say that for the purpose of ensuring that my prohibition law is not flouted by clandestine means, I will issue a direction to the breweries that this is how you will exercise the power, exercise the manufacturing process of bringing denatured alcohol. Lord, therefore, Lord, even for the purpose of, my lord, a very right concern expressed by your lordships, the solution is a directive by the center under the IDRA that this is how you will have to control. Because this is not a problem, my lord, only in the prohibited states. I mean, states having prohibition.
No, everywhere.
This is everywhere because of financial reasons.
Except in the prohibition states, the stakes are much higher because you can't get it lawfully.
Yes. Lord, there are.
For the more stricter the regulation, the more the people want to evade, right?
Yes.
That's why in the prohibition states there's a premium for people who want to evade. And they extract that premium. It's a hard fact.
There are certain things, my lord. For example, even where there is no prohibition, now people are fed up. We have studied something with the regular kick which the alcohol gives. For some states, you know, I can't name the states, it doesn't look good. People consume, you know, very regularly 1 or 2 bottles of cough syrup, because that's they say it's a different kind of a kick. Your lordships would be amazed. Iodex, which is used, you know, for the purpose of some pain, etc. Iodex. They not only smell, they put it on a jam like put it on a bread like jam, and they eat.
In fact, usually these NDPS bail applications, the recovery of 3,000 bottles of cough syrup. Codeine. 3,000 bottles of cough syrup.
Lord, for example, white ink, the eraser ink. So eraser ink, my lord, is a product, my lord, where we used to use it, my lord, when you used to have a manual typewriter. That is being used for intoxication, my lord. Then, my lord, though eraser ink may not be within the state subject, which have you to ensure that it is not misused, the state can, my lord, on that very logic regulate even eraser ink. That white ink, my lord, your lordship, all of us, my lord, have used it before. These people may not have known, my lord.
Erasex.
Yes.
That product is called, that
Yes.
whitener.
Whitener, that's the correct one, no?
Yeah,
Whitener.
those ballpoints also where you just press it and then it comes out.
Yes, sir, that was also.
Earlier you had those brushes,
Yes.
small brushes.
Stencil,
That's right.
See, that is not an intoxicating liquor at any rate. It is an industrial product.
No, I am saying something else. Say, for example, hypothetically, this whitener or white ink is controlled otherwise by the center under some entry, but with a view to avoid its abuse, it can be controlled by the state also if this argument is, if this interpretation is right.
Under entry 6 of list 2, health purpose.
No, I am saying under 52 they cannot do it. But if there is any other power, of course, my lord, nobody can take away except, my lord, by amending the constitution. The entry, my lord, my respectful submission is your lordships would go by the generic sense of the word rather than abuse, my lord. If we go by each entry, its abuse may find place, my lord, in some other entry as well, in some other list as well. And, my lord, I will show when I come to the scheme, my learned friends have already shown 18G of the IDR Act. There are power to issue directions that you do this, you do that, etc., etc. And, my lord, maybe regulations can be framed for that purpose. That's the answer. Conferring power and tracing it under entry 8 may perhaps not be the correct position. My lord, now kindly come to page 36. My lord, we have borrowed this expression from British legislations.
My only submission is my friend arguing that synthetics is wrong?
Entry 8.
Synthetics says the power is there to regulate industrial alcohol.
But we are on the I'll respond, my lord.
Paragraph
36, my lord, page 36. There is a chart, my lord. My lord, we have borrowed some of the expressions from the British legislations. how British used to, because this has come from 1919 and 1935, at least during the British regime. So we can safely rely upon what they used to consider intoxicating liquor. And I'll show about the statement of objects and reasons of this act, the Licensing Act.
Before we read this, your submission is that intoxicating liquor means something which can be consumed
As it is as a beverage.
by a human being. And if there is an abuse, there are other powers, other entities which can take care of that. That's what some of
Cannot be, in my submission, cannot be traced to entry 8.
There are other entities
Because it
which
is
can take
potable alcohol and Lord, UK Parliament enacted the Licensing Act.
Many of these acts which you have brought into the chart are also those covered in Balsara. Are they some of these also? Because we'll have to deal with Balsara. We'll have to answer Balsara. Many of these I think are in Balsara also, right?
No, Lord. Balsara has not analyzed these acts.
It has not analyzed it.
It has not analyzed.
I thought some of these are also the ones which Balsara.
But Balsara mentions this, but they have no, Balsara doesn't analyze it. And I would wish to show.
They find mention in the judgment. They
Yes,
find
yes,
mention.
yes, yes.
That's what I was asking.
Yes. But please, Lord, see page 36, intoxicating liquor, and I'll request your lordships to read, which is not, Lord, taken note of by Balsara. The definition of intoxicating liquor means spirits, wine, beer, porter, cider, perry, and sweets, and any fermented, distilled, or spirituous liquor which cannot, according to any law for the time being in force, be legally sold without a license from the Commissioner of Inland Revenue. Now, please come to, my lord, page 578, volume 4B. Lord, preamble of this act. Lord, this is not taken note of by Balsara, my lord. The lordship gets, madam? Volume 4B, page 578. An act for regulating the sale of intoxicating liquors. Well, the same expression we have borrowed. Please see. Where does your lordships get, madam? My lord Justice Sena? Whereas it is expedient to amend the law for the sale by retail of intoxicating liquors and the regulation of public houses and other places in which intoxicating liquors are sold, and to make.
Okay. 578.
I'm sorry, my lord, page 578.
Yes, I got it. Yes. Yes, what are you reading?
Lord, I'm reading the preamble of an act for regulating sale of intoxicating liquor. It is Licensing Act 1872. So intoxicating liquor is the expression, my lord, we have used in our constitution. Volume 4B. My lord Justice, my lord.
No, it says it is not applicable to Scotland.
Maybe, my lord, I'm told there are separate acts, my lord.
No, most of the scotches are from
Scotch is, yes, my lord. The Scotch is made in Scotland. Whereas it is expedient to amend the law for the sale by retail of intoxicating liquors and the regulation of public houses and other places in which intoxicating liquors are sold, and to make further provision in respect of the grant of new licenses for the sale of intoxicating liquor and better prevention of drunkenness. A human being is necessary. And intoxicating liquor, my lord, please see section 3. No person shall sell or expose for sale by retail any intoxicating liquor without being duly licensed to sell the same, or at any place where he is not authorized by his license to sell the same, any person selling or exposing for sale by retail any intoxicating liquor which he is not licensed to sell, etc., etc. my lord. Please see about section 5 also at page 579. Your lordship gets, my lord, at the foot of
Yes.
page 579.
Yes.
Look, the marginal note is seller liable for drinking on premises contrary to license. If any purchaser of any intoxicating liquor from a person who is not licensed to sell the same be drunk, that human element of my lord getting intoxicated on the premises, drink such liquor on the premises where the same is sold or any other highway adjoining or near such premises, the seller or such liquor shall, if it appears that such drinking was with the privity or consent, etc., etc. But similarly, see, 6, drunkenness is the subject matter. My lord. This is the regulation which the state can make. 6. If any person having a license to sell intoxicating liquor not to be drunk on the premises himself takes or carries or employs or suffers any other person to take or carry any intoxicating liquor out of or from the premises of such licensed person for the purpose of being sold on his account, so and so, so and so, so and so. Kindly see last 3 lines. The purchaser thereof on the premises of such licensed person with his privity and consent, and such licensed person shall be punished accordingly in manner provided by this act. This is the regulation which the state can make. Similarly, 8. Every person shall sell all intoxicating liquor which is sold by retail and not in cask or bottle and is not sold in a quantity less than half a pint, etc., etc. This can be, my lord, then offences and penalties at 582. My lord, I am not
the meaning of the expression sober as a judge?
Not sober as a judge, but from the point of view of the bar, has nothing to do with alcohol.
That's a good one.
The question is which part? Which part?
Main expert who is going to argue now in your side, following your argument.
On alcohol?
I didn't say that. I just said domain expert.
I can come back after, my lord. Your lordship knows about the story of Shankaracharya. But I'll just take 2 minutes. Shankaracharya used to do Shastrarth, which is a debate with everyone. So he went to a very great scholar and a very elderly rishi. Shankaracharya was very young, obviously. It's called
Mandana Mishra.
Mandana Mishra. And Mandana Mishra said that you are young, I am very old, so I'll give you one advantage. You choose the judge who will decide who won. Shankaracharya says that your wife, who is also equally learned, will be the judge. And the debate started. The wife started realizing that my husband is losing. So at some stage, almost at the end, she said that I am the wife of the contestant and I am Ardhangini. So I am also supposed to ask you certain questions. I'm entitled to ask you questions. She said, technically you are right, you can ask me questions. Then she started asking questions about sex because he was a celibate. So Shankaracharya was taken aback. He said, then give me some time. Then he, the Parkaya, Pravesh, etc., it's believed, he learned about it and thereafter answered it, my lord. I can answer, my lord, after this long weekend. After becoming a domain expert. But ultimately, my lord.
That was telling that some of us are with him.
But, my lord, she declared Shankaracharya to be the winner. The wife eventually declared Shankaracharya.
The final question sealed the victory.
Yes.
Final question.
Yes. Lord, now please see, my lord, page, and none of these is considered in Balsara, my lord. They note the act.
We won that.
632, same volume, my lord. Yes, my lord. Page 4B. Lord, this is House of Commons debate. This is not taken note of by Balsara. I am just showing, my lord, how Britain used to conceptualize or consider or define the term intoxicating liquor. Lord, Mr. Herbert Roberts, your lordship gets, my lord. Because we have the imprints of this law, my lord, let us face it. The expressions are, my lord, the same. Your lordship gets, my lord, the Chief Justice gets one.
Yes.
Mr. Herbert.
This is pertaining to intoxicating liquor and drugs in India, although the
Yes,
debate is in
British India. Yes. I beg to ask the Secretary of State for India whether he is aware of the number of shops open for the sale of intoxicating liquor and drugs in India rose from so-and-so to so-and-so, that the net revenue on liquor and drugs consumed in India for the year so-and-so, an increase of so-and-so, so-and-so, and last, shops opened and consequent increase in consumption. The Secretary of State for India, Mr. Bodrick, answers, the increase in the number of shops was considerable only in the two provinces of Bengal and central provinces. In Bengal, it was chiefly due to the fact that many shops sanctioned but unlet in 1902 were let in 23, and in the central provinces to the government taking over the excise arrangements in certain semi-feudatory areas and to the consequent more strict enforcement of the law. As the increase of revenue in 1982 to 3 over 1901 to 2 in these two provinces was not marked, the additional shops could not have had much effect on consumption. But they also use it in the sense of consumption in shops. But how we regulate? How would the state regulate potable liquor? They will give license that only licensed person can sell. The licensed person will have this much capacity. The licensed person will have to make certain arrangement for securities. The licensed person will have to ensure that it is not sold or consumed in public places. That is the regulation contemplated under Entry Act. If somebody abuses it, that is not within the domain of the state. So similar, I'm not duplicating 634. It further goes, my lord. Hours of sale of intoxicating liquors, page 634. Herbert Roberts asked the Under Secretary of State of India whether he is aware that Government of India have expressed an opinion in favor of curtailing the hours of sale of intoxicating liquors. Sale of intoxicating liquors as beverages, my lord. That is how it has always been understood. Whether he has seen the statement, etc., then I'm not duplicating. But please see the answer. The next, my lord, Herbert Roberts asked the Under Secretary for India whether he is aware of the almost unanimous consensus of opinion amongst district officers in Bombay that the change from the unrestricted auctioning of license has resulted in a noticeable improvement in the management of liquor traffic, whether since the introduction of the fixed fee system in Bombay, there has been a substantial diminution of the consumption of intoxicating liquor, etc. But intoxicating liquor has, this is only to show, intoxicating liquor has always been understood as meaning something which is sold as a beverage, which has an impact on impact of intoxication on human beings under licensed premises or under a valid license. And when we say human consumption, we necessarily say human legitimate consumption. Last act at page 37, I am not reading it. Intoxicating liquor, sale to persons under 18 Bill 1923.
Page 630.
37. There are two acts, my lord. I'm sorry, one act which remains. Last, my lord, in the chart. Intoxicating liquor, within brackets, sale to persons under 18 Bill 1923. Lord, your lordships can just note page 636 of the same volume, but it is using the expression in the same term. So my respectful submission is, your lordships would consider using this, giving interpretation to this expression the way it has always been understood. Lord, for example, snake bite is the latest form of kick in some cases. Lord, suppose it is capable of being converted into a drink. It would be intoxicating. It may have some amount of liquor, we do not know. Would it be treated as an intoxicating liquor? Well, the answer is no. It is alcohol-based drink which is served as a beverage for human beings, having the effect of intoxication, which is popularly consumed. Now, my lord, I would wish, my lord, your lordships to have what is alcohol and its forms, my lord. So that is at page. I'll come to Balsara a little later when I take judgments, my lord. All the judgments I'll take simultaneously, and then I'll show the scheme of IDR, my lord. Page 50, if your lordships can see, my lord. This is, my lord, sitting with the officials, my lord, we have prepared this. that what is the type of alcohol? Your lordships were taken through them, my lord. There is some deviation. Your lordships would like me to skip this one?
Well, yeah, I'm discussing something else.
Please.
Well, which para?
My lord, I am on page 51, para 60.
In the same volume,
Yeah. Same, written submissions, my lord. 2D. Lord, I am on para 60, page 51. Rather, my lord, if your lordships can go a little back, my lord, para 58. That may give a little holistic picture, my lord. And then I'll show, my lord, the scheme of the Industrial Dispute Act to demolish that this very fundamental argument that 18G is the only provision is absolutely fallacious. The Act occupies the entire field. But para 58, your lordship gets one. My lord, the Chief Justice gets one. Para 50. The term alcohol means ethyl alcohol and any strength and purity having chemical composition C2H50H, OH, sorry. Ethyl alcohol, which is non-potable, is a very vital and widely used raw material in several industries such as pharmaceutical and drugs, rubber, petroleum, etc. It is used as an anti-freeze material in automobile radiator. It is also used as antiseptic. It is also used in preparation of ether, chloroform, iodoform, so and so. It is also used in manufacture of drugs, perfumes, etc. Ethyl alcohol is used as an industrial solvent for paints, lacquers, dyes, varnishes, cosmetics, etc. So far as alcohol is concerned, the following details are relevant. Alcohol is derived through a distillation process where carbohydrate, sugar or starch is fermented and then distilled to extract alcohol. Alcohol can be made from any feedstock which has high content of carbohydrates such as sugarcane, rice, maize, potato, beetroot, etc. In India, alcohol is predominantly made from sugarcane juice, molasses, a byproduct of sugar production, broken rice, and maize. Major types of alcohol are given below. Rectified spirit. Rectified spirit generated after distillation having minimum 95% of ethanol content is used only for industrial purpose. It is used for industrial purposes such as use as solvent in paints, industrial chemicals, etc. Then extra neutral alcohol. This neutral spirit having minimum 96% ethanol content is made by further purifying the RS, that is rectified spirit. This is used both for potable alcohol and industrial purposes. Then absolute alcohol, also known as absolute alcohol having minimum 99.6% ethanol content, is also an industrial alcohol and is produced by further removing the water from rectified spirit and used in pharma industry. Now, denatured alcohol refers to alcohol products adulterated with toxic and or bad tasting additives, that is methanol, benzene, pyridine, castor oil, gasoline, so and so, making it unsuitable for human consumption. Please mark this. Denatured alcohol is not fit for human consumption. It is used in fuel blending, making disinfectants, tinctures, varnishes, preserving biological specimens, industrial solvents, etc. Then, my lord, potable alcohol for human consumption can be categorized, that is India-made foreign liquor. Normal standard is at 42.8%, and country liquor varies from state to state, but between 25 to 35%. Please see, my lord, the chart which we have prepared, my lord, in consultation with the officers. My lord, first is molasses, sugar syrup or grains. Then this is the raw material. Please note this, my lord. This is the raw material for production of alcohol. Then adding water and enzymes for fermentation plus grinding in case of grains. That is the preparation. Third is fermentation. Time is taken up to 72 hours. Then distillation means removing of water and impurities to get pure alcohol. From where three things which we can obtain. One is a rectified spirit, only used for industrial purposes in industries such as paint, chemicals, etc. That is minimum 95% of ethanol weight per volume. Then absolute alcohol is made upon dehydration, that is called industrial alcohol, used in pharma industry. And on the right hand side, your lordship would find upon further purification of rectified spirit or ENA, we get industrial use depending upon the market conditions. Look, this is where regulation comes. Some industries go for only industrial alcohol, and some industries go for alcoholic beverages, that is scotch, whiskey, rum, gin, etc., etc. Now on the left hand side again, if ethyl alcohol undergoes the process of denaturation, we get denatured alcohol, which is toxic. The argument was denatured alcohol is fit for human consumption. I'll show it is toxic. It is not fit for human consumption. Toxic, unfit for human consumption, and used to mix in fuel, disinfectant, making tinctures, varnishes, preserving a biological specimen, etc. My lord. Now please see, Lord, there is one judgment, my lord, VAAM Organics, which directly deals with denatured alcohol. Lord, one of this judgment, VAAM Organics, my Lord Justice Oak had an occasion to deal with in Bombay High Court, sitting with Justice Chagla. It is authored by Justice Chagla, but your lordships have seen this, my lord. I'll just read page 54, para 61. At this stage, it is required to be pointed out that it is absolutely wrong to suggest that denatured alcohol is either potable or fit for human consumption. As a matter of fact, the additives are added in pure alcohol to make it poisonous, bad taste, foul smell, and to discourage its human consumption. In some countries, it is also dried so that it can be identified visually. Some dry, it should be dyed. Lordship, kindly allow me to, it should be DYED. It is used as a solvent and as a fuel for alcohol burner and camping stores, apart from having other industrial uses. This fact is judicially recognized by this Honorable Court in the judgment of VAAM Organics. Lord, I'll just read this para. Before proceeding further, it will be proper to understand the difference between industrial alcohol, denatured spirit, and potable liquor. Ethyl alcohol is a rectified spirit of 95% weight per volume in strength. Rectified spirit is highly toxic and unfit for human consumption. However, rectified spirit diluted with water is country liquor. Rectified spirit, as it is, can be used for manufacture of various other products like chemicals, etc. Rectified spirit produced for industrial use is required by a notification issued under the Act to be demonstrated in order to prevent the spirit from being directed to human consumption. Rectified spirit is denatured by adding denaturants which make the spirit unpalatable and nauseating. As such, rectified spirit can be converted to potable liquor, but once denatured, it can be used only as an industrial alcohol. The process of denaturation described by the respondent is narrated by the High Court in the following terms. My lord, I can skip that. Eventually, my lord, it says that denatured alcohol is toxic. It is made toxic so that people don't consume it. In some countries, it is even dyed. Dye is added to it. So the argument that denatured spirit with some dilution can still be consumed is fallacious. My lord, I'll come to, my lord, the position of sugar, etc., my lord, a little later. Now let me take your lordships to the industrial development and regulation. Lord, I want, my Lord, some statistics to be shown that why this regulation is necessary. Lord, for example, during COVID, the maximum requirement was that of this, Lord, sanitizer, alcohol-based sanitizer. The government did issue directions. They were under the Essential Commodities Act because it is stricter, but it can be issued even under the IDR Act. They don't produce anything, don't produce the potable liquor right now, produce only industrial alcohol. Government issued directions, my Lord, Chief Justice is aware, in some other context, my lords have seen this. When we needed oxygen, all steel plants were closed down. That you will not manufacture, because every steel plant has oxygen generation stations. They generate industrial oxygen.
Which is far more purified than the regular.
But they were all directed not to generate any industrial oxygen, generate only medical oxygen. And medical oxygen used to be transported everywhere. But I'll show you those figures, why this regulation is necessary. Lord, kindly see, my Lord, ideal.
Political issue.
Volume 4, 547. Your Lordship, my Lord, I may be permitted to use for limited purpose, my Lord, the book. 547. The statute, my Lord, Industrial Development and Regulation Act. Lord, the purpose is to show, at the outset I may say, that 18G is not the only section. The Act as a whole occupies the field and there is, my Lord, a manifest parliamentary intention to occupy the field. Your Lordship, may kindly see section 2. Lord, I'll take your Lordships to the history of this Act a little later. First, let me show the Act itself. Declaration as to expediency of control by the Union. It is hereby declared that it is expedient in the public interest that the Union should take under its control the industries specified in the first schedule. But this is a declaration contemplated under entry 52, list 1. Correct, madams? Now, please see, Lord, scheduled industry is as specified. Please see section 5. Establishment and constitution of Central Advisory Council and its functions. For the purpose of advising it on matters concerning development and regulation of scheduled industries, the central government may, by notified order, please mark this, Notified order word is used at more than one places. I'll have to squarely meet with that argument. And I have an answer. Respectfully, my lord, I would try and persuade your lordships. Notified order, establish a council to be called the Central Advisory Council. The advisory council shall consist of a chairman so and so. Your lordships can skip, rest is not necessary. Section 6, my lord. Establishment and constitution of development council and their functions. Rest may not be relevant for your lordships, my lord. Please see subsection 4. Your lordship gets, my lord, subsection 4. A development council shall perform such functions of a kind specified in the second schedule as may be assigned to it by the central government and for whose exercise by the development council it appears to the central government expedient to provide in order to increase the efficiency or productivity in the scheduled industry. Please mark this, brother. The productivity comes or group of scheduled industries for which the development council is established to improve or develop the service that such industry or group of industries renders or could render to the community, or to enable such industry or group of industries to render such service more amicably. But pausing here for a minute, please come to Schedule 2. Lord, your lordships would get it, my lord. I'll just show, my lord, some of the functions so that your lordships may not have to go through all the functions, my lord. These are the second schedule 6.4. Does your lordships get, my lord? Oh, it is at page 598, my lord. Same volume, 598. These are the functions of the council which will advise the central government, and central governments thereafter takes actions if required. Lord, 1, function number 1. I'll read, my lord, only those which are relevant for the present matter, my lord. Recommending targets for production, coordinating production programs, and reviewing progress from time to time. The production is a regulated activity. Then 2, suggesting norms of efficiency with a view to eliminating waste, obtaining maximum production, improving quality, and reducing cost. All this is regulated. 3, recommending measures for securing the fuller utilization of the installed capacity and for improving the working of the industry, particularly of the less efficient units. Promoting, then my lord, 5, promoting standardization of products. The product is directly, my lord, controlled through the council. Then 7, my lord, promoting or undertaking inquiry as to materials and equipment and as to methods of production, management and labor utilization, including the discovery and development of new materials, equipment and methods of improvement in those already in use, the assessment of advantages of different alternatives, and the conduct of experimental establishments and of tests on a commercial scale. But when we say promoting or undertaking inquiry as to the material and equipment for method of production, it necessarily includes raw material also. That you procure raw material in a particular fashion so that your maximum productivity and efficiency is improved. My lord, last 14, my lord, promoting the adoption of measures for increasing the productivity of labor, including measures for securing safer and better working conditions and provision and improvement of amenities and incentives for the workers. Lord, your Lordships may also see 10, my Lord, and 13, my Lords. I'm sorry, I missed that. Promoting or undertaking scientific and industrial research, research into matters affecting industrial psychology, and research into matters relating to production and to the consumption of use of goods and service supplied by the industry. Even consumption can be regulated. If the council advises, there can be a direction from the central government. This is how the consumption will be utilized. The consumption of non-potable alcohol. And my Lord, 13, investigating possibilities of decentralizing stage and process of production with a view to encouraging the growth of allied small scale and cottage industries. It's a comprehensive regulatory mechanism. Lord, now coming back to the Act, my Lord, please come to page, section 10, page 553, my Lord. Section 10. So it's absolutely fallacious to say that 18G is the only section which is occupying the field. The entire Act, there is, my Lord, a well thought of intention of the legislature, of the Parliament, to occupy the field of regulation in whatever manner possible. Right from, my Lord, sourcing the raw material till consumption. Lord, your Lordships may come to its registration of existing industrial undertaking, but please come to subsection 3. Lord, I am not wasting your Lordships in time, my Lord, for what is not relevant. Subsection 3. Where an industrial undertaking is registered under this section, there shall be issued to the owner of the undertaking or the central government, as the case may be, a certificate of registration. Now please see, containing the productive capacity of the industrial undertaking and such other particulars as may be prescribed. The production is regulated in the license itself. Then, my Lord, 4. The owner of every industrial undertaking to whom a certificate of registration has been issued under this section before commencement of the Amendment Act shall, if the undertaking falls within such class of undertaking as the central government may, by notification in the official gazette, specify in this behalf, produce within such period as may be specified in such notification the certificate of registration for entering therein the productive capacity of the industrial undertaking and other prescribed particulars. If specifying the specifying the productive capacity in any certificate of registration issued under subsection 3, the central government shall take into consideration the productive or installed capacity of the industrial undertaking as specified in the application for registration made under subsection 1, the level of production immediately before the date on which the application for registration was made under subsection 1, the level of the highest annual production during the 3 years immediately preceding the introduction in Parliament, the so-and-so amendment bill, etc., etc. So production is very much a controlled item. Now, please come to 11.2. Now, this is licensing of new industrial undertaking. Subsection 2. A license 554, page 554. Your Lordship gets him. A license or permission under subsection 1 may contain such conditions, including, in particular, conditions as to the location of the undertaking and the minimum standards in respect of size to be provided therein, as the central government may deem fit to impose in accordance with rules, if any, made under section 30. Lord, the central government can even say that your location would be here because your raw material is here, and therefore the transport time would be less giving you more efficiency and more productivity. Then, my lord, 11A. The owner of an industrial undertaking not being the central government which is registered under section 10 or in respect of which a license of permission has been issued under 11 shall not produce.
More than what?
Very hard proof.
I apologize, if I'm getting a little monotonous.
Section 11, right?
11.
11A we were on.
11A. So you will not produce or manufacture any new article unless, in the case of an industrial undertaking registered under section 10, he has obtained a license for producing or manufacturing such new article. If you want to produce new article, that production needs another.
What a draconian act, Mr. Solicitor.
Well, it's not under challenge.
I know, but
Correct, man.
completely an anachronism in
All
India today.
pervasive. All pervasive.
My lord, I'm
Completely different economy, different regulatory regime.
my lord, that is going to be my answer when I answer the notified order.
You can't produce a new product until you have a license in respect of that product.
My purpose is not, my lord, I'm not,
We understand. We are not, there's no challenge to this act.
there is no challenge, my lord, but the
It's
purpose
just
is,
now saying, I mean, reading these provisions,
purpose is twofold. And I'll, my lord,
license Raj, absolutely. This was part of the license
yes,
Raj.
it used to be called a license.
That was the concept that they had.
91, we have, the industrial policy 91 downwards, my lord, is diluting the license Raj. I'm not on that. The power is there, whether it is to be exercised or not, that depends upon the facts and circumstances.
Just
But
as
I'm
an
just
aside-
showing-
Just as an aside, I mean, it has nothing to do with this case. Has the coverage of the act been brought down by the central government by,
Yes, yes.
by deleting industries from the schedule? Or
No, not amending the schedule by, for example, there was potable, non-potable, it is now only non-potable, etc. my lords. But I'll point out, my lord, answering your lordship's question. And my lord, I'm not, my lord, answering it right now. I elaborate.
These sort of acts are they're designed to kill productivity, not really enhance productivity. Because I mean, imagine interesting to some bureaucrat somewhere in the ministry, if you want a new product, you have to be licensed to have the new product.
I fully agree with that. The purpose of pointing out is that productivity is a field occupied, number one. Number two, and my lord, I'll be very careful in answering this question. When we talk about regulation, so regulations are of two types. I'm going to develop it, my lord, with some assistance from other side. And kindly, my lord, listen to this very carefully, because this is my answer to notified order. Lord, whenever the Act says notified order, by way of a notified order, it gives an enabling power to the central government to do or not to do. A regulatory power can be of two categories. A positive regulation, an active regulation. By doing something, you will not do it, take license, without license, don't do it. License also have conditions, etc. The second mode of regulation recognized throughout the world is regulation by forbearance. That right now I am not regulating, but that is the reason, that is the way I am regulating, by making a conscious choice of not regulating. But I have the power. Lord, suppose a situation arises like, Lord, COVID, then we can step in. Otherwise, my lord, this is an area which I will assist your lordship with, my lord, when we say notified order. Absence of a notified order is a regime of forbearance, that let the market forces play. Everything is going hunky-dory. There is no difficulty. We don't need to step in. But if the circumstances so exist, there is a statutory backing under which we can step in. But that conscious choice is regulation by forbearance. This is one of the concept which is developed throughout the world in all regulating bodies. So, my lord, my purpose of showing the provisions of the Act is to twofold, that there is occupying the field. The Act occupies the field. Good, bad, indifferent, constitutional, unconstitutional, etc. That's not the question right now. The Act occupies the field, but it is regulating by forbearance. When we say license Raj is given up, doesn't mean that this Act is repealed. The Act is not acted upon by a conscious economic policy call, but that is also a regulation. Therefore, you can regulate by not issuing a notified order.
What you were telling us just a while back, the switchover from potable alcohol to industrial alcohol, sanitizers and the industrial oxygen to medical oxygen, all that power or exercise under this 1951 Act.
Yes, yes.
Notification.
And suppose, well, Lord, even for non-potable alcohol, which is a scheduled product, scheduled industry, the central government can make a conscious choice that we will not regulate. We will regulate by forbearing to regulate. Let the market forces play its role. We will watch the market forces, and if everything is going on which is in national interest, maximum productivity, equitable distribution, etc., we will not step in. But we have the power to step in. So that is regulation by forbearance. So there is no notified order, meaning thereby we are regulating by exercising the regime of forbearance. And that's the new concept, Malal. That's a new concept worldwide in all regulatory bodies, that you retain the power and choose not to regulate. But that is also a choice. That is also a power of regulation.
As we read, and as we read along with you, we find that, so many nuances are there, and it's good that you're pointing it out, but it actually is capable of interfering in every facets of anybody doing anything.
That's my purpose of showing.
No, that
The
you are
purpose
so,
is that it occupies the field.
but it is inconsistent with what the government is saying all along. I mean, I'm talking about not in the context of the challenge.
We are in a forbearance regime, but the act occupies the field. That's the limited purpose of showing this. I am not showing that this is all I can do. I am saying this is all provided for, and therefore there is a law which occupies the field, which is not under challenge on the ground of unconstitutionality. But right now, your lordships are examining whether, if the central law occupies the field, which is traceable to entry 52 list 1 and entry 33 list 2, then the state government's power is ousted. I am showing it occupies the field.
So you are saying, irrespective of whether there is a notified order or not under 18G, I have the power to issue a notified order, and therefore the states are outstripped by my creating that opportunity for myself.
The reason is, I will develop it, my lord. Since it fell from your lordships, this is a draconian, my lord. I just wanted to say that we are in a regime of forbearance. But I'll develop that, my lord. And it may sound a little, my lord, ambitious argument on this. But, my lord, world over, regulators are exercising regulatory power of regulation by forbearance.
But
Mr. Solicitor, not this kind of regulation. Regulators are exercising different kinds of regulatory powers, not like
Your
this.
lordships are,
Every time you want to set up an undertaking, you will license it, new product license.
your lordships are not examining Article 14. This is not 19(1)(g) or 14.
This whole statute is an anachronism in today's age. It's a complete anachronism.
Lord, your lordships are, my lord, I am with respect, my lord, repeating, right now the only thing which your lordships would see is whether by a good law or a bad law, the field by central legislature is occupied or not. Whether that law is valid or not is not the question.
But the law itself, that is section 18G says, if you want to regulate, you have to issue a notified order.
Lord, there are 4 or 5.
Notified order, you can regulate.
There are 4 or 5 places where notified order.
No, where is the regulation?
And look at the kind of products it covers. Cutlery, calculating
Again, your
machines,
lordships are, my lord,
vacuum cleaners, sewing machines.
Lord, I'll show, my lord, that there are only 4 industries which are under regulation. Others are forbearance regime. That's the economic policy of the country, my lord. But your lordships are again, my lord, examining the validity from 14 and 19(1)(g) point of view.
Economic policy therefore means, because obviously the government is on the one hand demonstrating that we are moving increasingly to market-driven economy.
Market-driven economy.
A market-driven economy, you attract investment, you want to
Correct,
create a
my lord.
business-friendly climate, and therefore there is forbearance from enforcing this,
Lord,
except in regard to 4 industries.
I'm sorry, my lord.
But therefore, we can't say that then there is the doctrine of occupied field. The government, it's a conscious decision not to implement the provisions of this act.
Yes, my lord. But I'll show that. I will show that, my lord. The right now, my lord, again, your lordships are persuaded, your lordships have persuaded yourself, my lord, to go into Article 14 and 19(1)(g) arguments, which not, my lord, right now my purpose. My purpose is good, bad or indifferent. There is a provision which occupies the field and we have chosen not to implement that so far. Maybe, my lord, suppose, my lord, there is a defense industry. My lord, defense industry is one of the exceptions in Article 24, list 2, because of.
So, which are the 4 industries in relation to which the act is now
I'll show,
actually
I'll show
enforced by the government?
I'll show that. But let me complete the scheme of that.
It's about 5 to 4. We have to go for Justice Bose's
I know.
the farewell.
Can I start, my lord, on the next?
We were on. We had come up to section 11A.
11. But, my lord, please do not examine it from the point of view of constitutionality.
And Mr. Solicitor, now how much time will you take?
My lord, your lordships would, my lord, agree that I have never repeated anything.
No, not at all. Just
And-
no, absolutely. We are not trying to tell you that you have. But
Lord, I think, my lord, 1 session and 1 hour, my lord.
if Mr. Solicitor, if you can wrap it up in 1 session,
My lord, the difficulty.
so we can give 1 hour to the people who are following you. After you, who's going to argue?
I'll definitely, my lord, make an attempt, but your lordships would, my lord, not mind my saying this. No, Tikaramji doesn't consider any of these.
That point you will make, absolutely you've made. No, we are not saying that, you are.
In one brush, one line, it says that it's only for manufacture.
Mr. Solicitor, we are not rushing you at all. Just, if
No, I'll not try to be as
if
precise.
you can wrap it up by the first session on Tuesday, then, the others can wrap it up, say by 3 o'clock.
Wednesday, possibly Tuesday, your lordships knows, maybe a miscellaneous day.
No, Tuesday is, no.
No.
Wednesday is a holiday.
Wednesday.
Wednesday is a holiday. So we have Tuesday and Thursday.
But I have no difficulty, I thought because Monday is a holiday. Monday is not a holiday.
You were thinking about the long weekend, taking the Monday into account
Yes.
for educating yourself.
The child in me has not died, so far, that the school is closed, that I get the same thrill.
But you wanted to educate yourself on certain passages.
You have to
become
you have to be in some good company over the weekend. Mr. Philip.
Yes, madam. Yes.
If you can't look,
Yes, sir, it has.
if for reasons of professional ethics, you can't look to your right, you can look to your left. You'll find some good company on this side as well.
Yes, sir.
So Tuesday we'll come.
Tuesday, obliged to launch.
16, there are 2 directions, some constitution benches for directions that, but it won't take more than 5 minutes each.
The 902, madam.
Light motor vehicles and that arbitration.
Obliged to.